Hello. I'm going to wait a minute or two. I somehow messed up the dates, and so I don't know why this was originally scheduled for next Thursday. I don't know what happened to the schedule for today, but we're here now. So, yeah, happy Thursday, everybody. Hope you're a little thirsty. Because I am. I also have 2 dogs begging for cheese. I just finished eating lunch. And actually, I have my cheese stick left to eat. Anyways. So, update on my plant propagation. I had my ivy. Whew. I haven't attached them to the wall yet because I've got to get, clearly the bookshelves are still there. I did have a little bit of a backslide this last week with my health. And then I got that. I lost one. And this one right here does not look like it's doing well. And I just refilled the water. They still had water. And they are starting... doesn't look like this one's starting to root. But I've seen roots on some of them. I don't know. I have the curtains open all the time, and they're actually linen. They're really thin. I made them myself. So, anyways, that's the plant propagation going on. I'm hoping to get these bookshelves out of here. As you can see, I still have totes of stuff back there. I have empty boxes for storing stuff. What we're going to be doing is moving everything to my mother-in-law's house. Because that's where we will eventually reside. So the stuff we don't need is going to go there. I did not do my hair today. I kind of got caught in the rain this morning. I saw last night when I got home that my lavender needed to be harvested. And there were only 2 sprigs that I couldn't get. So with lavender, you harvest it right before it blooms. And if it's bloomed, it's not good for drying anymore. So I have only lost 2. I have my whole big old my bin right there. Hopefully I'll get at least 2 harvests this year. Last year I got 2 good big harvests, which is very unusual. So I'll probably be tying up lavender during this live stream. But I know what you guys are all here for. And I don't know, it might have a little something to do with my hat. If you guys haven't seen this one, I think I showed it last week. I spruced it up a little. I made it a little prettier. Although I want more red glitter. I got red glitter glue at Michael's. I think I'm going to go back and get the loose glitter as well. And I'm going to put the loose glitter on it so it's shiny. I used the red glitter glue, and then I had this black glitter. Because the headband is actually black. So, I don't know. I like glitter. What can I say? Oh, the other thing is we're going to count how many times I crashed the live stream on accident because of this stupid back and whatever button on my mouse. I have not bought me a new one. I keep forgetting. But let's get over to Judge Aaliyah Sabri's courtroom for our current favorite Moorish American or Moorish national. I forgot his name. Oh, wait, hold on. I swear, you guys, I am with it today. There we go. I swear. Wait, I have to put my headphones on. Oh, I told you guys, it's been a day today. Got woken up at 8 a.m. Uh-oh. Got woken up at 8 a.m. They were removing the concrete from the yard across the street from us and then breaking it up in the back of the truck, in the bed. So that was a very lovely alarm clock this morning. Courtesy of construction. Okay. Here we go. Oh, yes, we do have a brief appearance by Chief Judge McConaughey.
Morning, Ron.
McConaughey, sorry.
Good morning, everyone.
Good morning.
Are you ready on the motion for Michael? Is it McCreary?
McCreary, that's his name.
Yep.
All right. The clerk can call the case.
2356485, the people of the state of Michigan versus Carnell Michael McCreary. Mr. McCreary is charged with count 1, assault with intent to murder. Count 2, assault with intent to rape, violent, harm, less than murder, or by strangulation. Count 3, weapons, firearms, possession by a felon. Count 4, weapons, ammunition, possession by a felon. Count 5, assault with dangerous weapons, felonious assault. Count 6, 7, 8, 9, and 10, weapons, felony firearm. With the habitual offender fourth defense notice set for a preliminary examination today.
Oh, I forgot. I completely forgot. I'm not an attorney, guys. Okay, so I'm not giving legal advice nor putting forth any legal conclusions. All comments are my opinion, irregardless of the verbiage that I use. So no matter what it sounds like, it is simply my opinion. All persons are innocent until proven guilty in a court of law. And last but not least, my videos are not court record. There we go. Let's go back to the video.
Before the exam, there was a motion that was filed by Mr. McCreary to disqualify me from this case, and that is why Chief Judge Conoco is on Zoom to address that motion.
Okay. Appearances.
Edwin Sawaki, P54A28, appearing on behalf of the people.
Carnell Michael McCreary, natural person, not a corporation, natural flesh and blood.
Not a corporate fiction.
Okay. Thank you. Thank you for your appearances. The court did receive a motion to disqualify Judge Elias Sabri pursuant to MCR 2.003. The court, having considered the pleading and being otherwise fully advised on the premises, the defendant having moved to disqualify Judge Sabri, but having stated no grounds that meet the legal basis under MCR 2.003 that would demonstrate that the judge has shown actual bias against the defendant or defendant's attorney. It is ordered that the motion to disqualify Judge Sabri is denied. This order does not resolve all pending claims as to the remaining parties and does not close this case.
Hey, Rachel.
So the motion is denied. Thank you very much.
And Attorney Washington, I know you want to put your appearance.
Oh, yeah, I'm sorry. Yes, Earl Washington as the backup attorney.
May I speak, Judge?
That matter.
Now that matter is resolved now. The court is turning this back to, excuse me, sir. The motion was denied, and now the court is being turned back over to Judge Sabri to handle the preliminary examination. Thank you very much.
Well, can I at least place my objections on the record?
It's been noted.
I mean, I'm just saying
Mr.
because
McCreary,
I thought you were the chief.
Mr. McCreary, your objection has been noted.
May I address the court?
Not on that matter. I can't hear a motion to disqualify. According to Michigan Court Rule 2.003, the chief judge has to address it in a multiple judge court. This is a multiple.
Who told you that so many times?
Counsel just addressed it. You received your motion in writing, and he responded on the record. He denied it. There could be no more discussion from me about the disqualification motion, Mr. McCreary. It's been denied.
But can I just address something? I mean,
it's already been addressed in your pleadings, and I cannot respond. I don't know if you understand. I can't respond regarding the disqualification.
I'm not trying to do that. What I was saying, per the rule,
Well,
the process.
You're still talking about something that has nothing to do with.
Well, I object, and it's on the record.
Yes, and I've noted that. So as far as the exam, the time is now 10:17. Are you ready to move forward with your preliminary examination?
I came here today with intent, like.
Yes or no?
No, I'm not prepared because of this. I mean, I would like, you won't let me speak, Judge. Like,
I
you give
let
him a
you
fair
speak in
chance
regards to what I'm
to
asking.
respond, but you won't give me a fair chance to say or speak.
Mr.
I mean,
McCreary,
this
I let
is,
you stand here for 45 minutes last time we were here talking to you, didn't have anything else to say. So today I'm asking you, are you ready to speak?
no, I'm not. I don't like to call witnesses.
Based on what?
Pardon?
Based on what?
Because my intent as today, this motion was filed, the court was supposed to deny it because I thought you were a chief judge pro tem. And per the motion, it says that if you were the chief judge pro tem, it's supposed to go to the state court administrator. This gentleman here, I'm not familiar. Like first,
You're still addressing the motion to disqualify.
my due process is being
And
violated, Judge.
it's not.
Yes, ma'am. You missed my intro. It is my mini fest that I decked out. Sorry, that was probably really loud. I forgot the microphone was right there. I put glitter on it, red glitter glue. I'm going to go back and get the loose glitter from Michael's, and I want the hat to be more glittery. And then I had some black glitter, and I used the red glitter glue and then the black glitter for the headband because the headband was black. Because, you know, I got to be super fly or something. Sorry for yelling, getting really loud. I'm sure I'm going to get yelled at about it later. But yes, I have a fez on because, well, he's not wearing his today. But that doesn't mean I don't get to wear mine in honor of our favorite Moorish sit. Yes. Wait, Moorish Aboriginal, I think is what he called himself once. All right.
I mean, you won't let me tell you
It seems
why.
as if you can read it right. The court rules are very clear about motion to disqualify. There's no black, it's black and white. So Mr. McCreary has been denied.
I'm glad you
And
understand.
if you knew that, it also says that there's a timing in which the court can address that, can be any time. So you knew you need to move forward with your exam today.
Well, what I'm saying is I have a right under 6.110 to call witnesses.
Yes, you
Things of
do.
that nature.
And why aren't you prepared today?
Because you won't let me speak.
I didn't know. I said, why aren't you
I'm
prepared today?
I'm trying to tell you.
Today's your exam day.
Can I respond? You keep cutting me off.
You're not answering my question.
I'm not prepared because when I filed this court was supposed to make a ruling. Then if you denied it, it was supposed to go to the chief judge.
No,
That is
I
the
can
process.
tell you no. It's not.
That's why I'm not
I
prepared.
can't deny a motion to disqualify in a multiple judge court.
Can I pull up the
Read the
rules?
court rules, 2.003.
I'm familiar with it, very good.
We're not that familiar.
Crafton versus Michigan Department of State,
You can
even if
say
you can't
anything
show
but
bias.
one in a multiple judge court. I cannot handle your motion that you filed. It goes to the chief judge. Chief judge, I am chief judge pro tem, two different things. I cannot handle my own motion to disqualify.
I was going to say, she also cannot do a motion against her. They're not allowed to hear those motions. So this guy knows this. It's been said I don't know how many times, but he's just playing games because, you know, that's what they do. It's time to play some games.
That would be bias, Mr. McCreary. So you have witnesses to be there.
You won't let me respond.
Yes or no?
No, I don't.
Okay.
Because my
Yes or
intentions,
no?
as I stated, under this
It's just a
rule.
yes or no. I just want to know. So you can finish looking under court rule 2.
Why am I not being allowed to address the court and give it a fair exchange like
I'm
the
asking you
prosecutor?
questions. This is not your courtroom. I'm
I'm
asking
not
you.
trying to
I
disrespect
have
this court.
given you all the leeway up until this point.
I mean, the law
Today's
gives
the
me rights.
exam day.
She has,
Go ahead and check your
actually.
court rules. Get back to me. Are the people ready to proceed?
Given him so much.
And I object, I'm not ready. Because, I mean, I would like to address the record for preservation rights.
Yes,
So
ma'am.
far as I have to go to the
You
higher
want to
court.
research 2.003 first?
Pretty sure I have that
That
one
seems to be
recorded
what you
somewhere.
stuck on.
I think.
I want you to go ahead and
I
find
mean,
that
there's
first.
Michigan case laws.
Or I stole it from
Court rule
Squishy.
2.003. Go ahead and find it. Tell me where it says that I'm supposed to address it.
You guys, I'm so
Okay.
afraid of hitting that
Section D,
back
you may
button.
raise, the party
I'm
may
crashing my
raise
stream
the
now.
issue of a judge's disqualification by motion, or the judge may raise it, excuse me. Disqualification of judge is warranted for reasons that include but are not limited to the following. The judge is biased or prejudiced for or against a party or an attorney.
Oh
B,
my
the
God.
judge based on an objective and
Those are the
reasonable.
grounds. You gotta get to procedure. Section D.
She's straight up telling him what to even look at, and she doesn't have to. Like, she is giving him so much leeway.
3A. Right there. I can read it for you. 2.003D3 under ruling.
I mean, I was getting out
One,
here.
in
You
a
say
court having
B3?
2 or more judges, on the request of a party, the challenged judge shall refer the motion to the chief judge, who shall decide the motion to no. That's what happened.
And that just happened at the beginning of this hearing.
The written order that will be provided to you stating this time.
I don't know what's going on in Kennedy. I have no idea today.
With the people's witnesses.
Well, I have evidence. I mean, since you're forced to compel it, which violates my rights under UCC 1-3. Wait, also, I'd like to make a non-pro time. Again, motion to challenge the jurisdiction.
Thanks for popping in.
After this, the hearing we had last, I believe it was the 30th, I believe it was. The prosecutor gave me 15 pages. He attested on the record. 15 pages all they had. There's no warning. There's no signature signing off for the prosecutor to initiate charges, whatever else. I mean, this whole case, I object to this case being moved forward under Brady violation, Fourth Amendment violation. I mean,
there are no Brady violations, dude.
Judge, you're allowing this.
Nothing has been presented to me.
I mean, I'm just saying.
I'm talking. Stop talking over me. You've been doing this since you've been in this courtroom. Every time you talk, I let you finish, whether it means it's meritless or not. I haven't heard anything of any substance or any value worth me addressing when it comes to Brady violations. So I'm ready to move forward. And if you want to call witnesses, if we have to hold in part because you didn't subpoena them today, we'll address that when it comes time after the people rest. So Attorney Washington, is there anything you'd like to put on the record before we begin?
No.
Any preliminary matters on either side regarding the exam?
Preliminary matters, yes.
People have to address the first.
Yes, Your Honor. People have exhibit 1, which I will show to the defendant and his Mr. Washington here. It is a register of action certified, case number 98007-861-01-FH. It indicates that defendant, Mr. McCrary, pled no contendere, assault with intent to maim, would like this as People's Exhibit 1.
Oh, you say, I was found guilty. Assault with intent to maim.
Dude, stop talking. He needs a mute button.
You said I was convicted of that?
Under what court, under what statute?
Oh, I'm sorry, Your Honor.
I object, I wasn't convicted.
MCL 766 11B 1B.
I object to that, Judge. I was not convicted of that. Matter of fact, Judge Dalton Robeson was a visiting court. And again, this gentleman is lying to the court. He just lied to the court. That's perfect.
And you had the opportunity to review the document?
Well, he said that I was convicted of assault with intent to maim. Can I ask that what you said?
I said,
Okay. The prosecuting attorney didn't commit perjury. He's not testifying and he's not under oath. So therefore, he can't be committing perjury. He's throwing around these words, which, I mean, perjury is lying, but it's lying under oath while giving testimony. So he needs to use the right words. It's lying, not perjury. Sir, that's how it goes.
I said, you pled no.
No. I wasn't found.
Mr. McCrary, you review the document?
Yeah. Okay, well, what does this got to do with the case? Robbery not armed, assault intent to maim. I have the transcripts at home. And the court order from Judge, he was a visiting Judge Dalton Robeson. Matter of fact, in that case, Your Honor, the prosecutor what was this, Thomas Beadle, I believe his name was, he said that the officer in this case lost his entire file.
Can I see the?
And I have this transcript at home. How you gonna speak on some of you?
Okay. The other aspect is they can't bring up past crimes. They can't use that against you, but he keeps bringing it up when he talks about, I think she's like the chief prosecuting attorney or whatever, the head prosecuting attorney for Wayne County. I forgot her name already. He wants to bring her on the stand and he wants to talk about his prior acts, but you can't bring in prior bad acts. So he is literally shooting himself in the foot. Well, not literally. He is essentially shooting himself in the foot by insisting on talking about his prior bad acts. If he had an attorney or he had standby counsel, he would know this and he wouldn't be destroying his own case, essentially.
When you lost a file, this case was the felony was. It was a misdemeanor, aggravated assault. That's the case is, because in the transcript that I have at home, I would like to make that in evidence after this is concluded or whenever I can. Because he's just lied to this court, Your Honor. That's perjury committed in court, Your Honor.
Okay, I have a seal here from the register of action sealed from the Wayne County Clerk's office stating that you pled no contest to.
That's an
I
act.
forgot to oil my chair.
That's an act, Your Honor. I had a transcript at home.
Can you let me finish what I have to say, please? The jury trial was held.
Jeremy, it's just, he mentions the name here in a little bit, so her name does get mentioned. But she's literally irrelevant to the case. It's hard to follow what he's saying because it's not logical. And so, yeah. But if you're having a hard time following, welcome to the club, Jeremy. Thank you for joining us today.
In front of Judge Roberson. Sentenced and committed to Wayne County Jail. Your sentencing on September 8, 2000. So for exam purposes under MCL 766.11B1B, exam purposes only. This satisfies with the, you can place your objection on the record.
Well, I would like to say because in this case, I have the transcripts at home. And I object because this man just lied to the court because in this case that Thomas Beadle was supposed to be special prosecutor. They held me in for 2 years. And he stated on the record, there's no support for this case. The officer in charge lost the entire file. So how are you going to present a register of actions? That's not evidence, Your Honor. I have the evidence at home. And I would like to object to this. And I would ask that
why is your evidence at home, dude?
For committing perjury.
I'm going to hold you in contempt of court in a minute. So I'm going to admit as Exhibit 1 over the objection of defense as a certified copy from the clerk's office for exam purposes.
I have been dealing with a lot myself. Got some health issues going on. My dad was back in the hospital, but he's home and he's doing great now, so that's good. And I'm just dealing with my health issues, which are not fun. But otherwise, I'm okay, and I'm glad that you're here today. I've missed you.
Only showing that Mr. McCree was convicted of felon intent to maim in 2000. Anything else for preliminary matters?
Not from the people here.
Okay.
Also, Judge, I would like to make a motion to sequester because my intention is to call the chief detective on the stand because.
Okay. You don't have to tell me a theory. I will do it.
Okay.
So let me do that first. So there's a potential witnesses on this case. Now is your time to log off. As far as in the courtroom, if there's anyone present who may testify on this case, maybe a witness, now's your time to exit the courtroom. What's Next.
Per the court rule, I'm allowed to get evidence for evidentiary purpose of impeachment on people versus Stanaway. I also would like to address to the court, Kim Worthy,
Kim Worthy, that's her name.
List out for officers who have previously
There you go.
testified
You got her name,
falsely
Jeremy.
in court proceedings that they couldn't testify in future proceedings. My brother, Norman McCreary, has committed perjury in front of Chief Judge, Wayne County Chief Judge Freddie G. Burton. He committed forgery, as well as identity theft. Also, I have affidavits from my other brothers where they've been trying to.
We don't like drama here.
And the prosecutor did not.
I try to avoid it.
Also,
Let me address that first.
Yeah.
So, Mr. McCray, if your brother testifies, you can definitely cross-examine him, impeach him, and bring all that out, and the prosecutor objects, will address it then. But you can do that on
I need to
purpose.
get y'all copies.
No, I don't receive copies until you introduce it and it's provided to the court. I don't do any preliminary impeachment. So once you cross him, if it comes out that he was convicted of a certain crime under the court rules or under evidence that allows you to discuss it, then that's your right to do so. Next.
I would just like, he was not convicted, but he was in the courtroom when it was established by the Chief Judge Freddie G.
And this is where standby counsel would be really helpful for him.
These years, and they're trying to come forward. And I have an affidavit on my phone from my brother that's notarized. He's in the state of Florida. And
the brother that's testifying
no,
today?
my brother Charles had 5.
Okay. His evidence, he has all this evidence at home. It's on his phone. But this is the probable cause conference. So if you want that evidence to be admitted, you need to have submitted it. But on your phone doesn't fly. Like this is why, if you're gonna represent yourself, you at least need standby counsel so they can help you navigate these little issues that go along with court. Unless you're an attorney, and even then I still would have outside counsel.
So you have to address your brother today when we cross-examine, okay?
Also, again, I would like to renew my motion to have the prosecutor's office withdrawn because of criminal misconduct, conflict of interest. My former attorney works for Kim Worthy as the director of the Wrongful Convictions Unit, Valerie Newman, and it is quite well documented that Kim Worthy, as well as my former attorney, committed felonies. And it's all a matter of public record. And
But
you
if
know,
they've
for
been
this
convicted,
gentleman here to come here and try to mislead the court, I believe it's under 3.3 of the Michigan Rules of Professional Conduct. It states once an attorney knows, I believe it is, that they have told the court something, they must correct it. And this prosecutor is committing misconduct because I have from a stenographer transcript at home, in which I would like to.
You know the avenue to do that. You want to report misconduct. You already know that. So let's get started with the exam. I've heard all of your motions and you place it on the record, and you will of course order the transcript to be able to move forward to the next step you want to do. So any other preliminary matters to address regarding the exam today?
Well, how about, I'm just saying this, the proper recusal aspect.
I'm going to deny that.
Well, can I place my objection?
Absolutely. I hear your objection. Everything else. Ready to file your first witness?
Yes, I am, Your Honor.
Mr. McCray, you want to sit at the table here?
I would ask that the
we got witnesses.
Be called first because we have to establish how.
you don't get to dictate the prosecution's case, dude.
Now that would be you working with the prosecutor's office. You don't get to tell them how to try their
No, I'm
case.
not saying that. What I'm saying is I want to question that investigation.
Okay, and if the prosecutor, are you going to address their request? Or call who you said you're gonna call?
I have one witness.
Okay. So in this case, he gets to
Well,
start with
can I
however he
call
wants to.
as a witness and that he's trying to bring my brother? I would like to
So
establish.
procedurally, the prosecutor has the burden of proof. You should know that. So
Well,
they have to go first. They have the burden here.
they have no
And then
evidence,
you
Your
can
Honor.
call
further.
witnesses if you like.
Ugh.
If you feel necessary, you can do that. We'll discuss that after the people rest, okay?
Yeah, they have no evidence, Judge.
You don't know what they have.
They just said it's in the paperwork.
I like you to stay focused, okay? And the first thing we're gonna do is your testimony for people's first witness. They have a burden. So please.
People call Norman McCreary.
Sorry, I did record this. I just didn't get a chance to finish editing it before I was going live. So we're going on the court stream. I apologize because I would have edited all this dead time out. So yeah, lots of people aren't who they say they are on YouTube. Absolutely, people are fake. But this is the real me. Actually, I'm probably not quite as dorky on here as I am in real life because I'm really a dork.
And microphones, when you're talking, you put that in the line. And Mr. Milwaukee, whenever you are ready.
Sir, could you state your name for the record, please?
Norman Leon McCrary.
And what brings you to court today?
The incident that happened on the 9th, and I was leaving the house after another incident that happened inside of the house,
Okay,
and I went to my next door neighbors.
okay. Let me back you up a little bit. Was that February 9th this year?
Yes.
Yes, and did that,
Objection leading.
Piece of paper.
No, I have.
Kisses to you,
Objection,
Dermot.
he's
Thank
leading
you.
with the truck.
I think, sorry, go ahead.
Because he said no.
One witness testified that it was night, I was merely clearing up the ass at the 9th of the month it was. or what month
Objection.
it was.
It's still leading.
Okay, listen, I'm gonna overrule on that because of the preliminary matters as far as date and time and we date night.
Was February 9th, correct, of this year?
Yeah.
Okay. And
People
then,
suck in general, Bruja.
what address did that occur?
14739 Homer, Detroit, Michigan.
Talk about fake people on the internet or people being fake on the internet.
Yes, my God.
Because all the CEOs work together. Now, you had confrontation, right?
Yes, if that's what you want to, yes, a confrontation where we talked after
Okay. Who did you have a confrontation?
Colonel McCrary sitting right there.
Did you,
Objection, Your Honor. I would like to also, there was a one single photo lineup, which he seen my picture prior to this event.
He's your brother.
Photo lineup.
He knows who you are.
And this is how, you know what I mean, he's my brother, truth. There's a procedure on the due process. Oh, okay. Yes, I would like, I mean, I'm good, but I would like to object because there was a suggested photo lineup used. If you look at the discovery, it says that a single photo was shown to Mr. McCrary. And this violates, what is it, United States versus Wade, I believe it is.
No, it does not.
However, Mr. McCree, that's fine. Very delicate to you represent yourself. But you just stated that he's your brother.
I mean, but it's still a procedure, Your Honor, that has to be followed.
I mean, this is one of the most easiest identification cases. If he knows you as your brother, he can
Mhm.
identify you on that day.
But it's still, it's suggested, it violates the law.
We're not even getting to the line at this point.
Well, I'll place my objection.
I hear you. So, Mr. Sawaki, keep continue with your questioning.
could you describe a piece of clothing that, the gentleman?
He has a blue jean jacket that I had.
You know, let the record reflect that, witness has identified the defendant.
It's not reflected.
What, at this address, you arrived at it, you had a confrontation. Could you go more into that?
Well, prior to, seeing, my brother Carnell, I had went into the house the day before on the 8th. And, the downstairs door, which is the part that I had, was kicked in and damaged. So, and then I went into the back room and the second door was kicked in and damaged. Objection, Your Honor, he just committed perjury. The first door is not kicked in and speaks of.
Sir,
Okay,
Okay, they do talk about it here. It's a little confusing though. So what they're talking about is a 2-story house, and essentially like the first floor is like an apartment, and then this top floor is an apartment, and they each have 2 separate entrances. One at the front, right where the living room is, and then one in the back, like a kitchen door. So they're talking about the upstairs apartment. If I'm correct, right? You guys, my memory today is shot. Anyways, it is 2 separate residences with each with the front and back door. So one's upstairs, one's downstairs.
okay, I'm sorry, I didn't know I had to say it. I'm sorry.
what you're doing is you're testifying as to what
Mhm.
happened. All you can do in this case, if you're saying that he's not telling the truth, on cross-examination, you have opportunity to question him and possibly raise issues of credibility. But that at this time, you're testifying as to what happened and not objection regarding the rule of evidence.
So you want to testify, you need to put yourself on
Your
the stand.
interjection has been placed
I
on
understand this, man.
And if I may finish, though, and upon going into the kitchen,
Second. Describe this house, is it like, is it apartment?
it's an income bungalow. So it's an upstairs and a downstairs. And
I've
it's
never
separate.
heard that term
They
before
both
today,
have separate
actually.
Utilities. And the downstairs
Income
is
bungalow.
the part of the dome that, I was, having, I became executive of the estate. So, I kept the house so that my other siblings, including him, could stay there.
Okay.
So I came downstairs,
Say him, who are you referring to?
Cornell McCreary. So when I came downstairs,
Just so the record's clear, whose estate are you talking about?
my deceased mother's estate, Mamie McCreary.
Who lived up, did someone live up in the,
Cornell McCreary stayed upstairs after he was released from prison.
okay. So, you came in and there was damage?
Yes, there was damage to the front door, the kitchen door, and a bedroom door.
Okay. What happened?
Okay, so
And this is
I,
on the 8th.
yeah, so I didn't have a camera with me at that time to take pictures of the damaged property. So I came back on the 9th, and then once I came back on the 9th, I took pictures of the damages that were, incurred in the house.
What, after you took your pictures, what did you do next?
I left the house and then I went next door to one of our neighbors she had fell sick and she had a pacemaker. So, she grew up, we grew up with her. She's like a mother.
Okay.
So I went next door and, visited her. And then upon leaving, when I was coming out,
Sorry, guys.
my brother was coming, Cornell.
Okay, you were coming out of the neighbor's house, where was your brother coming out?
He was coming out of 1417 home.
Okay, and that's where he lives. Correct,
He lives in the income bungalow upstairs.
okay. What happened when you got it?
He confronted me and, I told him, I said, so is this how you're gonna do our mother's house? And he was, he started talking about taxes, which he hasn't paid, So, and then I was like, man, I tried to ignore him. So he's like, you so you going to go to the police on me and all this kind of stuff. So, and, I was like, yeah, I'm going to the police. And he's like, well, somebody's gonna die today, need you or the police.
Okay.
So, and then I
Whoa.
ignored him. And
Whoa.
I went to
Hold on.
this kind of, and I tried to ignore him. So he's like, so you going to go to the police on me and all this kind of stuff. So, and, I was like, yeah, I'm going to the police. And he's like, well, somebody's gonna die today, need you or the police.
Okay.
So,
Good
and then
God.
I ignored him. And I went to my automobile,
Okay.
and I was about to get into the automobile. He picked up.
When you got into your automobile, what happened next?
That was
picked the brick
absolutely a
up and
threat.
hit the car with the brick. So I jumped out of the automobile
What?
and, ran after him and he ran. So, I was like, man,
Okay. Where did he run?
he ran up on the porch of 147.
That's crazy. That's insane.
When you ran up, when he's on the porch, what did you do?
I went, I ignored him and went back to the car because I was gonna go to our police.
Okay. So when you went back to your car, what happened?
Crazy.
He picked the brick up again and hit the car again. So
Jesus.
now this time I ran after him again and he ran up onto the porch, opened the door, and then came outside with a semi-automatic weapon and fired into the air twice.
Okay.
Good God.
Fired it twice.
Yes.
And then what did he do?
And then
I'm sorry, did you say into the air?
yes.
And he's a
Into the air
felon, so he
twice.
shouldn't even
And
have a
then he
handgun.
looked at me in the
Any
eye
weapons.
and then pointed the weapon at me and shot in my direction. And,
When he shot in your direction, where did the bullet go?
it's a field right across the street from the house. So I can't say where it went, but it went in that direction towards the field.
Well, what did that do to you as far as?
I was, first of all, I was upset that my brother would do something of that nature. Then, I kind of feared for my life, so I jumped into the vehicle. And
There's something wrong with him.
And you said the weapon was, what type of weapon again?
It looks like it was a rifle, it was a black, it could have been an AK.
But you're not sure, right?
No, I'm not sure.
Okay.
A rifle that.
And
Okay, I guess.
after you got your car,
I was really upset, and I went directly to the precinct and I filed a report.
okay.
And
I have nothing further for this witness at this time, Your Honor.
That's insane.
Does that make sense?
yes, I mean,
So he supposedly did that and still is behaving the way he is.
You are bound by the rules of if the prosecutor-
He is not fit to be in society. I'm sorry.
This is Washington, D.C.
How you doing there, Norman? McCreary?
I'm here.
You all right today? Okay, let me direct.
He straight up just used his brother's whole name. He's like calling him out. And he out here with this dude. I didn't realize like that all happened. I knew there was a gun involved, but holy crap. Now I know why like the attempted murder charge is there. There's something seriously not right in this guy's head. And this is beyond this Moorish sob sick crap that he's spouting, Dude. First of all, he is a convicted felon, so he should not have a firearm. So he obtained that illegally. Dude, he shot at his own brother, who was taking care of the house where he lives. I'm assuming probably rent free. I don't know. I just have the suspicion that he has lived there at least partially without rent because it was right after he got out of prison. But still, like, because he was going to call the cops. So you tried to kill him because you busted up doors? Dude, that's just crazy.
Let me direct you. You stated that I shot in the air. Is that correct?
That's correct.
Okay. Isn't it also correct that you said I shot the ground as well?
I didn't see you shooting the ground.
Well, no, I'm just saying, is it yes or no? Did you say I shot the ground?
I didn't see you shooting the ground. So
Okay.
that's
Your
it's
Honor,
not a yes or no.
I would like to reflect for the record that
that's a
another senior
problem.
prosecutor said that I shot the ground, shot in the air, and shot him in 3 stories. Okay.
Your Honor, I don't recall that, and
This
today
was
we have to
a,
go by testimony of the witness, that's what we're here.
well, you were the spokesman for it. You're
I represent the people, sir.
Okay, that's all right. Okay, you spoke about a probate issue, am I correct that you were the executive, sir?
Yes, I did.
Okay, isn't it true? Have you ever committed perjury or have you ever committed forgery or
Oh,
anything
Lord.
negative? Oh, Your Honor, you just lied. Here's the
How?
paperwork,
Prove it.
just impeached him with, isn't it true that you forged, my name?
What does this have to do with
Well,
what
it's
you did?
impeachment, sir.
Let it finish.
It's impeachment, sir. People versus Stanaway law, the rules of evidence. Isn't it true that you forged my name, David McCurry, Norman McCurry, Paul McCurry, James McCurry, and Charles?
That is not true.
Okay, I have affidavits from him notarized where he stated that the brothers gave him permission
Guess what? Bring
to sign
those brothers up on the
names,
stand during your hearing.
and the judge issued a show cause hearing. Give me a second, please. Okay,
He committed a crime he hasn't been convicted of, so
here's
that
an
doesn't
affidavit I
work.
would like to get a copy of to the prosecutor's office. It's signed and notarized by Norman McCurry. And this is allowed for impeachment purposes. He just committed perjury on the stand, Judge. And on page 2, Norman said that the other brothers, Charles, James, and Paul McCurry, agreed to getting the loan, the signing of their names. Oh, okay, yes. Could you, I'd like to give it to your witness and see it too. You just lied on those, sir. And it's signed and notarized by him in the Wayne County probate proceeding.
That was ordered by the judge. It was not, and I had to follow the judge.
Committed perjury. And I have an affidavit from my brother on the phone too, that he didn't give him permission as well. And I'd like to have, that's why I was saying my witness call judge.
F1.
Your Honor, this is just an affidavit. It doesn't show anything about perjury. And not only that, but
It's forgery, sir.
1 second, Mr. McCray, 1 at a time.
in order to be impeached, it has to be conviction. Therefore, I'm gonna object to this line of questioning unless the defendant can show that the witness was actually convicted.
Where is that case law? Show me the authority by that, that's why.
The court rules.
No,
The
that's
Michigan
your
rules of
job.
evidence Allow for.
He just
impeachment.
lied
Mr.
under oath,
McCray,
and he lied under oath in court. Just
you.
follow like this
Mr.
subpoena.
McCray, let me finish addressing the objection. Under the Michigan rules of evidence, to attack someone's credibility and to impeach them, you have to do it under whether or not the witness has been convicted of a crime involving dishonesty, false statement, or theft. If there's no proof of a conviction, I'm not sure how you plan on proving that with an affidavit that has not been verified by anyone, no court other than an affidavit signed by another person who's not here to testify.
This is affidavit. This is what I'm saying, it's signed and notarized, Judge. And then I was also.
That doesn't matter.
Transcript by police officer.
That can be
Wayne County,
forged.
from complaints about them, and the judge allowed me. I just asked him, did he ever forge anybody's names, whatever else?
He said no.
And he said no. And the affidavit shows that he said my other brothers agreed. I have affidavits from Charles McCurry and other people that say they didn't give him permission. This is a felony. This is a crime, Judge. How can you allow
So call the
this
cops.
gentleman to come in here?
You, Mr. McCray, you have to file a police report for that crime.
I tried to.
Well, I can't.
They ignore. They've been vindictive to second
Mr.
prosecution. Your
McCray,
Honor.
I'm not allowing you to present an affidavit. There's no conviction of the 3 things, dishonesty, false.
Okay, can you show me in the rules of evidence where that is? It says about conviction, because other courts, I remember, I can't.
That's not her
judge
job.
From 99, he was here, he allowed.
1999.
Yes, Capers P. Harper was my attorney at the time. There was a deputy sheriff named Clifford D. And we asked for additional discovery to impeach him. And the judge allowed it at the time. I have this document at home as well. This is for purposes of impeachment. He just lied and said he never forged nobody's signature. And that doesn't equate to conviction or not.
Yeah, but you're not asking for additional discovery. This is 24 years later. So laws and rules have changed. you have not actually filed a motion to ask for discovery or further discovery. You haven't even asked orally for further discovery. So that was weird. It sounded like something fell, probably inside the gun safe. Yeah. Anyways, this guy is so I can't with him. I can't do the mental gymnastics, you guys.
Or not. I have affidavits saying that, yes, he forged my signature, he committed felonies, and he did what he did. And this is his affidavit of truth.
Saying that he committed felony?
It shows that he said.
Yes or no? Does it say he committed felony?
Yeah, right here. It said that Charles and them agreed for him to sign their names. My brother has an affidavit saying that he did.
That's not saying I committed felony.
Forgery is a felony.
I know it. So
Identity
is lying,
theft
so is shooting
and
people,
perjury.
so telling people you're gonna kill them, so is murder. There are a lot of crimes.
So that's discrimination on your part
If it
because
hasn't
you
been
allow what
proven
he's
or
saying.
established, then what do you expect me to do?
Well, I have the affidavit showing this contradicting what he's saying per my witness,
For the rules.
Charles McCreary. And I would like to admit that in evidence as well. Because he's saying that he didn't forge these people's names, and my other brother's saying that he did. And this was perjury.
Michigan rules of evidence.
And can you give me the rule?
609.
609, okay.
609.
Go here. You just lying under oath this time. MRE 609.
For purposes of attacking the credibility of a witness, evidence that the witness has been convicted of a crime shall not be admitted unless the evidence has been elicited from the witness or established by the public record finished during cross-examination, and the crime contained an element of dishonesty or false statement, or the crime contained an element of theft, and the crime was punishable by imprisonment in excess of 1 year or death under the law under which the witness was convicted. So the issue here is that there was no conviction. So
Okay.
I'm not admitting that evidence.
Can I
On to the next question.
Can I give you speak about the rule?
I'm denying
What?
that you disagree and object to my.
Take that up on appeal,
Yes,
Judge.
I do object, and this goes also, again, I would like to renew my motion to recuse under People versus Traffic, Michigan Department of State, Traffic versus the Department of State, Kane versus MBOC, because this court is being biased, and there's previous proceedings where the court allowed these types. Yeah, under in this court in
I didn't
99.
do that.
Well,
This whole claim about the court being biased was literally just heard at the beginning by Judge McConaughey. So him saying this again, I mean, literally, it was just done like half an hour ago, I think. We're about 30 minutes in. So no. Also, I want to, I'm going to change my little banner at the bottom because brand color. Anyways, Detective Rachel McCreary, I said that. Rachel McCrae, there we go. Her daughter just graduated high school, and she also graduated and had her certified nursing assistant certificate or license. So her daughter is going to go into nursing school, and we all know here in the U.S. we are just so understaffed everywhere. Every medical office, every hospital, everything's so understaffed. So Rachel started a GoFundMe to help defray the costs of her daughter in nursing school, and that is the link there at the bottom. It's also in the pinned comment. That is her GoFundMe to help her daughter. So if you guys have a couple pennies and you feel like you want to do something good or whatever, if you feel like donating, that would be awesome. Probably going to be putting this up for a long time because school's expensive. Even if she's just getting her 2-year RN, an associate's nursing, that's still a lot, and tuition is expensive. Loans don't necessarily always cover everything, especially outside things like food or pencils and those types of supplies. So if you feel like you can donate some, that would be awesome. Let's get back to the video now. It's this ranch dressing of tossed word salad. Yeah.
What I'm saying is I asked him a question. He said, no, I have evidence to show you.
He's trying to use all the words, guys.
And
There
it
was
involves,
evidence, 609, that allowed for you to establish that. Next question, Mr. McCray.
okay, now here you just spoke on the rule, and I would like to argue the rule. It says unless listed, I solicited.
Why are you
You
don't argue the rule in front of the
And this
court.
court, I feel, is being
That's
biased.
the
toward
wrong
the
venue.
It sounded like a broken record. I heard it already.
All right.
Denied.
Okay.
Next question.
Can I continue? And I object again.
Please.
Mr. McCurry, isn't it true that you consider yourself a sovereign citizen?
Huh!
Does that have
You
to
do
do
too,
with-
you.
Well, it's relevant. It's relevant.
Yeah.
For credibility impeachment, Your Honor.
What?
I object to the relevancy of the question.
It goes to
You
the
are a
credibility
Moorish
of the witness
soft
and to
dude.
test its credibility.
So stop.
People versus
Stop.
Stamp. People
Mr.
versus
McCray,
Stamp.
the case law, you can stop right now. Rules of evidence.
Uh,
How is this relevant to the case here today, whether he's a sovereign citizen? And don't say anything about dishonesty, because you are too, and you've established.
Yes!
I said, don't say
Yes!
anything about dishonesty, because you stated that you're a sovereign as well.
I mean, yeah, I agree.
So
I'm not.
hold up.
Your Honor.
I object to the relevancy of the
Gonna
question.
hear
It
this
goes to the
again.
credibility of the witness and to test its credibility.
So stop.
People versus
Stop.
Stamp. People
Mr.
versus
McCray,
Stamp.
the case law, you can stop right now. Rules of evidence. How is this relevant to the case here today, whether he's a sovereign citizen? And don't say anything about dishonesty, because you are too, and you've
How am
established
I being
that.
dishonest?
I said, don't say that it's about dishonesty, because you stated that you're a sovereign as well.
I mean, yeah, I
Yeah.
agree.
So
I'm
what is the
not
relevance
the
of
straw
him being a
man.
sovereign today
I'm
while
not
he's
the straw man. What I'm saying is,
Answer the
Oh.
question. How is it relevant that he's a sovereign citizen?
because he's the same person that fights you down. In court, he's issued,
What?
I'm
affidavit.
I'm indigenous to this land, so you should answer.
Both
Here
of
we
you
go.
all, in a minute.
They're
you're gonna
indigenous to
examine
this land.
at least the contemporary, don't lie. You
So
all
am I.
I don't care if he's a sovereign citizen or not. That has nothing to do with the case here today. So I don't find it to be relevant. So next question.
So you stated that I shot in the ear, is that correct?
Yes,
Okay, you also stated that I shot at you as well.
yes.
Okay, is there any witnesses to this? And what time was this about?
Well, I can't remember this young man's name, but him and his mother was outside.
Okay, so what time was this?
I can't remember.
Can't recall. Does the people have this information, Judge, if he doesn't know the time that this occurred? Because on this day, I was at work.
It was
I
after
was at
work.
work in Oak Park.
It was around probably after 5.
You just said you didn't know, Mr.
Well, I said I don't remember, but if I try to recollect, then I would say I get off work at 4:30, so it had to be after 5.
Okay, are you familiar, do you recall that I worked at Glory Supermarket in Oak Park?
I don't know, I didn't know where you barely
Okay,
worked.
now let me ask you this, for your birthday, didn't I get you 2 bottles of rosé for your birthday? And I told you about I got you.
Objection.
Well,
So
no, I'm trying to establish that he knows that I wear.
when the judge
This
objects,
is what, this is
I knew
what.
that you had got a job, but yes, you
At a
did.
supermarket.
Yes, you
Okay.
did.
To the McCreary's.
oh no, it was the other prosecutor.
Everyone stop talking.
Thank you.
For a couple reasons. The court reporter, you are torturing her right now because she cannot
Oh,
take
wow.
down anything when everyone's talking. So please,
She can't hear
one at
nothing.
a time. There's an objection on either side. Stop talking. So there's an objection. What is your objection?
Relevancy.
What is the relevance of the 2 bottles of
Well,
rosé?
to establish that he knew where I worked at, so that I can let it be known that I was at work during this time that he claims whatever this stuff is going on.
Okay, even if he doesn't know where you work, I'll let.
Wait a second, hold up. Okay, because he got his brother 2 bottles of wine. So that then means he knows where the brother works. because I don't work at a grocery store and I can go get 2 bottles of rosé within like 15 minutes because it'll take a minute to drive into the village to the store. So how is that even remotely relevant, dude? It's not. It's completely irrelevant.
On that day and time.
Okay, that's what I'm
It's when you
saying.
bought 2 bottles of rosé.
Time in which you were at work.
Well, the time of the crime that he stated, I mean, if how do you not know what time the crime was committed? You saying the date, but what time?
We're talking about you went to work, where you worked, or the time.
Well,
of
what I'm
Because
trying
said
to,
it after 5. It had to be after 5 because you worked until 4:30. He doesn't know the exact time. Is that my understanding of what he said? Is that correct?
well, I worked afternoon,
Is that correct?
part.
He said after 5 because he didn't know work at 4:30. Not sure what time, somewhere after 4:30, after 5. Is that correct?
I mean, this is what he stated.
That's all I want you to say. We all agree on what was said. Okay, so he doesn't know the exact time. I understand. Next question is, how is the 2 bottles of rosé relevant to the day of the
Well,
event?
the reason that I stated that is because he knew where I was. I was telling him about how cheap things were there with my discount. So he just stated he didn't know where I work, but he knows where I work. Because I gave him 2 articles from the job for his birthday.
Okay,
And then I have witnesses that I would like to call in, Robert Van Dyner,
okay.
Gerald
You call that
Flowers,
when
and
it's
other
time
people.
to roll it.
Yes, because Mr. McCreary was paid money. This is why, He's-
Mr. McCreary.
okay.
Last
All right,
question
let me-
about
okay.
examination.
Mr. McCreary, isn't it true that you allow Mr. Robert Van Dyner and Gerald Flowers to rent the downstairs at some
I'm
point?
gonna object to relevancy.
Well, I'm trying to establish that Mr. McCreary is committing crimes, past and present. This is what this is about for purposes of impeachment.
No.
What?
You have, I read the rule, 609. Unless you have
Happy minute.
some other route, you asking questions about,
Well, the thing is, he's stealing money. If you look at the taxes, like the taxes is still in my
and
mind.
guess what?
After
Even
10 years,
if
20
he
years.
That's still irrelevant.
It wouldn't be relevant today during this testimony.
So he can steal from me and that's okay. And other people, it's okay.
That's not a thing.
And I've made reports, and the 10th precinct is
I'll be right
retaliating
back,
because I
guys.
made reports against their officials down here to failure to protect.
You are
Judge.
muddying the water, not staying focused on what has been charged on this case.
Well, I'm being denied my rights. This is what I.
So I am going to sustain the objection, it's not relevant. Question.
Okay, isn't it true, Norman McCurry, that the taxes mainly McCurry are still in her name after 20 years of being the city servant?
Yeah.
No, it's this your witnesses committed felonies and you're committing felonies with them. You don't work.
Okay.
And there is documented, I'm just, this purpose of
Is this,
impeachment.
well,
The purpose of it.
okay. Okay, next question.
May I ask you a question? How did you come to work here at Courtroom? How did you get here? Did you drive or were you brought?
Objection, Your Honor, relevancy.
Relevancy is Mr. McCurry is driving, he has no license. And
Okay,
he's
are you
breaking-
just trying to
he's breaking-
tattletale on him for
No, I'm
everything he does all
impeaching,
day?
he's breaking laws, but I'm being accused, I'm innocent.
Okay,
I'm innocent,
it's still not
Judge.
relevant to the allegations and to what he testified to on direct examination.
Well, if I may respond, the relevancy is that Kim Worthy has executed things against police officers, but the witnesses are being allowed to commit perjury and get on the stand. This violates the officer's right, equal protection clause of the 14th Amendment. Because if officers have testified or lied and they were convicted,
What does the officer have to do with anything right now?
well, this is the witness.
He's not an officer.
He's a witness though. It's just,
It's not
if
the
you,
same. This is a very specific case. We have specific testimony. I don't care if he has a license or not. So sustain.
but what I'm saying is,
I don't care if he has a license.
well, the police and him, they're being allowed to commit felonies, but I'm here to be accused. And this is,
You
I'm
have
trying
to
to
be.
establish,
You're not being, you have it.
okay, I'm being accused. I'm have been accused, yes,
Next
and there's no evidence. Mr. McCurry, can I ask you a question? Did you know that there is no evidence in this case?
Objection.
Why?
Relevancy, how would he, he's not an officer.
Well, I'm just saying, there's no evidence.
And actually, there is evidence.
Where is this here?
Your Honor, his testimony is evidence.
That's not evidence under Upper versus United States.
Under the Michigan rules of evidence, testimony is evidence. Next question.
Okay, now object under Upper versus United States, testimony without cooperative evidence is not evidence.
Yes,
Jackson
so
versus Virginia.
That
Wait.
is incorrect. Next question.
I just say I'm being lynched today by this court as well as my brother.
Is this your closing argument? Because you can say that.
Well, I mean, you won't let me bring nothing in. You're shooting down everything that I brought in because of judicial bias.
It's not
Well, other
accurate
courts that
under
hold
the
it
Michigan court rules of evidence, under the Michigan court rules, under the rules of evidence. So I'm not lynching you. I'm denying you certain things that you're doing because it's not applicable and
Okay.
proper in court.
All right, now may I respond to the rules of evidence, statement that you
No,
made,
you can
Judge?
ask the next question that's relevant. to
Okay.
the point here.
I have to say that Judge Sabri is actually becoming a favorite judge of mine. She's like, I don't care. I don't care. Oh, she is. I'm loving it. I am loving it. And yeah, can you build me a little hut so I can join you? We can have some sheep. And I'll like spin yarn with the wool. And can we have good Wi-Fi so I can still watch YouTube or whatever? Please? Please? I promise I say it to myself. Okay. Anyways, let's get back to the case. I don't know. I want to strangle him. Not an actual threat. But yes, I want to strangle him.
Well, I mean, I can't ask everything. You shoot down everything I bring it, Judge, and I
If you don't have
object.
any more questions on cross, then you can say no more questions. Have a seat. You don't have anything
I'm
that's
being
relevant
denied.
to. the
No Wi-Fi, no
direct
deal.
evidence that was provided, or the testimony addressed.
Well, may I address something that you stated, Judge, if I may?
Question to the witness.
I mean, I just yield because I'm being denied my rights, and I object to this whole proceeding because I'm
You're not
denied
being
to present
denied your
evidence to
rights,
call
dude.
witnesses on my
No,
behalf.
you haven't been
To
denied.
properly
You don't have a
cross-examine,
question for you
to
even
properly
put
cross-examine the
next.
witness, and then they're charged me with strangulation. It says injuries. No, this man is not hurt. He hasn't been shot. They got weapons and strangulation. I do all this to women.
That's just the charge, dude.
I'm trying to
You weren't
understand.
charged with strangulation.
Yes, it's in here.
It says or by strangulation.
Okay, well, the first part.
So, it's great,
Okay, assault with intent to grave bodily harm. He has not been hit. He hasn't been hurt. He hasn't been anything happened to him.
Woo!
Where's the medical report?
So, get to that in the argument.
Dude, he testified to, and I do believe there's an officer that is going to testify to the fact that you pointed a gun at him and fired it. So how is that not attempted murder? Like, even if your intention was to miss, you're still firing a gun at him. That's still assault. That is great bodily harm. Absolutely. Holy crap, dude. Like, does he really think this stuff? Or is he just spewing this nonsense because he thinks it might make him win? Oh my God.
You'll learn elements. of
I mean,
that.
I just object and I'll rest and I'll leave it to the circuit court as
You
well
can't
as.
rest, you haven't even had an opportunity.
Well, I'm
to
just
present
saying
witness. Do you have any
because,
more questions of the witness?
I mean, I'm being denied my right
Yes,
to properly
or no?
cross-examine.
Do you have any more questions?
Sorry, dear Mitch.
I'm denied the right to proper cross-examine.
Can you redirect?
No reject, no rejection. People have no further witnesses.
Mr. McCreary, do you have any witnesses?
I would like to call the chief officer that's the investigator on this case, and I also object to him not calling any other witnesses at this juncture.
Oh my God, you
because
can't tell him what he's
witnesses-
doing with this case.
And I would like all witnesses to be brought here so that I may properly examine and cross-examine these witnesses.
Did you subpoena
Because
them?
they, They don't have a warrant, Judge, like after we had the hearing when he attested to court, I just had 15 pages, this is all that we have. Where's the warrant, Judge? How am I charged? Where are magistrate's signature?
So as far as, this is the probable cause here, this is
Okay.
not, let me finish. This is not trial, okay? So the people do not have to present anything but what is necessary to show probable cause, not beyond a reasonable doubt. So if they want to call one witness, they can. If you want to call the officer in charge on the case,
Well, can I call all the policemen that are on the list? Since he's not calling,
you need to offer a proof,
or,
offer of proof as to why you need to call them.
well, because their investigation. This is what I want to question them as to their investigation. How now the law is, I cannot be tried for a crime that I haven't been charged with. There has to be a complaint, warrant, and a request for a warrant, and there's not anything here. How was I even charged, Judge? And there's no warrant.
So,
And out of the 15 pages, I looked, and that's a violation of the Fourth Amendment to the U.S. Constitution, Judge.
you said you wanted to call the officer in charge?
Yes, it's the officer in charge.
Okay,
And the other officers.
now, I will allow for the officer in charge because he's here, correct, Mr. Milwaukee?
Correct.
Okay, for the rest of them, you did not subpoena or bring anyone today. for
Well,
the-
I didn't know he was not gonna put them on here. They're
It's
on
not
the
his
list.
job to call your witnesses.
No, what I'm saying is they're on his list as witnesses. And I would like to basically get the court to
He
have
did
a
not
clear
provide a
understanding.
witness list for the exam.
It's a
In
list here.
discovery and investigation report, I believe that's what you're referring to.
Yeah, right here, the prosecutor's office witness list. I have a right to this.
Okay,
I
so
would like to cross.
you have a right to interview them and subpoena them to come to court.
Well,
And
to
you have
establish,
the people to make them available to interview also before.
yeah, I understand.
Okay, today we're here.
Well, in the
And-
6.10, it says I have a right to examine, cross-examine the witnesses of the prosecutor as well as myself.
You do.
And they had an investigation. I would like the court to have a clear understanding so these charges can or cannot be established properly under the due
I
process.
will allow you to call any witnesses that you have subpoenaed that are here today, as well as the people's witness, the officer in charge on this case will call.
This is why you need
Man.
Call that.
attorney.
Oh, yes, but man, I object to the court's denial of my Sixth Amendment right to call witnesses in the
They are the most delicious ones ever.
Because to establish a proper investigation, this court to be full aware of what is going on with this case and the evidence concerning this case. I mean, these officers have to be brought forward so that we can ask them how they did the investigation.
I can ask my OG BFF, but I know that in his prime he ate some crayons because he's a Marine. But I think he said purple was better. Maybe it was red. Or maybe that was Skittles. Oh, I forgot now.
And I believe that is a matter that you may, if you get bound over, can address at trial. There were several motions. The proper cause here, Mr. McCreary, very minimal.
Well, I mean, the rules are clear and under due process,
They
the
don't seem
statute
to
of
be
due
clear
process.
because you still talking.
Well, may I address the court? I mean, you give him the full rights to speak, but I'm always cut off.
Well, it's because you're saying things that really aren't relevant. So the officer in charge is here. Do you want to call that person to stand?
I definitely will.
Step up to the court reporter, give her your name and spelling.
There's something wrong with you, dude. But that's all right.
Make sure
I want all weirdos here.
Whenever you're ready, Mr. McCreary.
Can you give me
like this, sir?
pardon? I'm here. Can you give me your name and badge number for the record, sir?
Officer Edward Wowski, -4753.
You say Pulowski. Okay, so you're the officer in charge,
Yes.
detective? Okay. On the day in question, what time did Norman McCreary come into your station to make?
I don't know the exact time to see it, even right at the incident.
Right after this, then, so you didn't take the initiative to write down what time he came in here? He came to your office?
Your Honor, I'm gonna check the foundation. It hasn't been established that This witness actually took the report from the witness.
Okay, so where's the other one?
Clarify that.
Okay, I'm like,
Lay a little bit of foundation as to
well,
what he's
if
involved in.
he's the head
Mr.
officer,
McCurry, lay a little foundation, which means ask questions about his involvement to get to
I
the fact
understand.
that you're questioning whether he did a time.
I understand.
Right.
Okay, did you,
You don't
are
understand.
you the only
dude.
one that had contact with Mr. McCurry?
No,
Okay, may you tell me who Mr. McCurry started having contact with, in the beginning?
the officer Clannon who's working the desk.
Officer Clannon.
Clannon.
Clannon?
Clannon,
Oh, Clinton, okay,
Clannon.
Clannon, okay. So, who took the
Clamid.
report of Officer Clannon?
Officer Clannon took the report.
Okay, and this is the report that's in this file that I may, this report here, sir?
You wanna,
I mean, I'm just asking, is this the report that the
I don't
officer
know,
took?
can you see that report?
That's not a report, so that is a written statement.
Or written statement?
Wait, can you guys hear my chair squeaking over the video or not? Because I can hear it. It's driving me bonkers. But can you guys actually hear it?
Statement? Well, it says in the interview, like, if questions are asked, and then the officer is writing the questions, then he's writing the
I'm
answers.
gonna, Jack, because it hasn't been established that this witness has taken that.
Well, he's the chief officer in charge of the state, so everything falls on him, just like you're supporting him working, sir.
No,
Everything you do is falls on her.
No.
What are you trying to establish?
Well, I'm trying to establish time, place, and things of that nature. I mean, there is allegations.
Let's take the very specific question you're trying to establish with this statement, what?
Well, I'm trying to establish a time frame. When did he come into the office? When did he speak? Who did he speak with? What time reports were made? You know, to clarify everything that's Norman Query stated.
Thanks,
So I'm
guys.
trying to lay a foundation as to this investigation.
Okay, and
Right.
that's not the document that the witness has prepared or is familiar with. If you didn't prepare that, then you can't present that to him and tell him to refresh his memory or recollection about it.
Well, no, I was just asking what time
Precious
it's going to
memory.
come in to make a report.
And your response was you weren't sure.
He said he don't know, so.
Yes, I mean, this is one of probably 300 cases I've had since then. I don't remember the time of every case that I have. It's all in the reports, which is public record.
Okay, so do you have the report?
Well, talking about for this report here, yes.
The witness just stated that he's not sure what time, but it's in the report. You have that report that he's referring to.
It says, I can't understand this reading. I mean, can you understand this? I mean,
Just-
it says in time.
Don't read to me on.
Oh, it says start. time,
Yeah.
five.
Mr. McCurry, when I read to me what's in the document, do you have it?
I have a police report, yes.
Okay,
I believe he still has a statement. It's written and it's a statement. The report is all time.
Well, this was taken on the 10th, Your Honor, the day after the fact that I was.
you have your report or your investigative report?
It's all in the jacket. There's an investigative report, there's the police reports, there's everything, the warrant.
I don't have a warrant. Where? It's not in here, Judge. He said he gave me 15 pages. He tested. This is all he had. I asked to see it. There's no warrant here. There's no authorization from the prosecutor. And then if he pulls anything else out, that's a Brady violation.
And you may,
Not a Brady violation,
It's
dude.
not
you
here.
don't even know what he's about to show you.
what I have, that was in the packet, discovery packet.
Yeah.
Troy Police request for a warrant.
I should, like,
Investigators.
don't take me off for every time it's
Page
some, like,
3,
Brady violation or something.
and it appears to go through page.
Ugh.
uh,
There's a national report.
And this is even signed by the prosecutor, where they recommend or deny a warrant request. This is not even signed, it's not notarized, these documents are not
Okay,
legible.
let's stick.
Oh
to-
my God,
you want
dude.
to,
Yeah.
present that report to refresh
Well-
his recollection about the time?
Well, no, I was asking him.
But that was the line of
No,
questioning.
that
we're on.
was not where I was trying to go. Where I was trying to go, I was asking him to get a basis. He stated that Mr. McCurry, my brother, came into the police department and made a report. This report showed that he gave a statement on the 10th, so how it happened on the 9th? He said he went in there on the 9th, and this is written on the 10th.
That would be the day after, This is you testifying, first of all. There's been no testimony that
Oh.
anyone came out and testified.
Okay, well, look, I'm just saying he's objecting to everything and I have foundation in it. Right to ask the question.
It's not objecting
Okay.
to everything.
Okay,
Oh my
so
lord.
you stated that you're the chief officer in charge of the state, am I correct?
I'm the officer in charge.
So you just stated under oath that you didn't know what time that Mr. McCurry came to the police precinct to make a complaint. Am
Not
I
the
correct?
exact time, no, sir.
Okay. Here, I would like to teach him. Did you guys seek a warrant from Kim Worthy's office on this day in question or at any time?
Oh God, here is
I remember what
Worthy
the
again.
exact, I guess we sent a contract back over to that prosecutor's office.
Okay, at your, what's the word? At your direction, did you order your officers to arrest me on the date in question, which when I was brought in for this case?
I didn't tell them exactly what day to arrest you, wasn't do any kind of felony case. I gave them a special operation, who works out of the 10th precinct. I know that there's probable cause to arrest somebody, and if they come across somebody, they'll lock them up on that case, yes.
Okay, was there a warrant, sir?
Not at that time, no.
Oh, is there a warrant now?
There should be, because you're recording.
No, sir. Right here, Judge, I would like to amend the evidence where right here, this is the Wayne County prosecutor recommendation, it's blank. It's blank. Now, my paperwork's supposed to be the same as his.
Your Honor, it is blank. The only thing that's different is that it's been redacted with the witness's address between his and ours. And that's perfectly legal, and that's to protect the witnesses unless there's a special.
You talking about the warrant, sir? Not the protection.
I'm explaining why the difference.
I'm not a threat to him.
So.
The last page of the investigation.
I beg to
report
differ
that's
on that
not
one.
That's set in with every investigation. The
Well,
authorized warrant is going to be the black and white with all the charges.
okay, can I ask you a warrant where?
So,
There is an information.
The objection, that's not signed, notarized, or approved by court, the court rule.
that would be a motion that you could address if this gets found over regarding the warrant.
Exactly.
Right.
Exactly.
Well, I would like to continue my cross-examination if I may, Judge.
Woo!
How
Wants to continue
long have you been
testifying?
an officer? Officer Palauski, you said it is?
Yes. In Detroit, over 7 years.
Over 7 years. Oh, you've been a police officer in another city?
Right.
May I ask, where?
City of Westland,
City of Westland. And you say you've been in Detroit how long now?
7 years.
Are you
I don't know why
familiar
you
with
would wanna
the
move,
Fourth
take that move.
Amendment to the U.S. Constitution, Article 1, Section 11 of the Michigan Constitution, sir?
I just put for a record that the officer isn't.
Well, but he's supposed to be a law enforcement officer. How you gonna be a law
You
enforcement?
know you don't.
Yeah, I know about
God.
that.
Okay.
Okay, again, was there a warrant when you arrested me?
I did not arrest him.
Well, your officers, you should know what your officers are doing. Notice the agents, notice the principal.
Question, what's the question?
Okay, did your officers have a warrant when they arrested you?
No.
Judge, I move for dismissal at this juncture because there's nothing authorized by the prosecutor or anyone else. And he just stated he arrested me without a warrant. This is a crime.
You can arrest you
I
on
would
probable
like to say
cause,
this.
dude.
In 2001, the Department of Justice indicted DPD for drag net arrest.
Okay.
And this
So
violates the
I'm
Fourth
denied
Amendment.
that request. You can be arrested without a warrant.
Can you show me the law where that is?
No, it's not my job to show you.
Okay, well, I'm saying under federal case law and state case law under Article 111 of Michigan Constitution of 1963, as well
Oh,
as
it's
U.S.
1963,
Constitution Amendment 4 enforced upon the states, they have to have a warrant, Judge.
32 hours.
72 hours.
Yes, it can hold you for 72 hours.
At
Well,
some point, I don't know,
mm,
but that's once again outside of the purview of this exam
well,
today.
they're committing felonies, Judge. This is the question.
Okay, and I am not the police department, I'm not the FBI,
May I
I'm not the
continue?
Department of Justice.
Go to
Charges
call
here
up the
today are
general's
self-defense
office.
murder, So I will continue to do great bodily harm, less than murder, or by strangulation. Weapons, firearms, possession by a felon, weapons, ammunition, possession by a felon. Assault with a dangerous weapon, felonious assault, and also 4 counts of weapons and firearms.
Okay, do you have any video evidence of when Mr. McCreary came into the station, like body cams, which are mandated by law? So far as the desk officer, or you give the interview, are these articles available?
There is no body cam footage used on the front desk. It was all reported at the station.
Okay, within the station, why haven't you put this, if that evidence into the discovery so that the people can have it? Sir.
That is requested from inside the station. Yes.
Okay.
It's not the officer's
I'm looking
job.
for this page. Okay. May I take you to, I believe it's page 6, Detroit Police request for warrant before you was off, please, sir?
I don't take anything. I don't take anything.
You don't have anything, okay. Can I get the court officer to hand this to the gentleman so I may question him about this discovery investigation? Okay.
Last page.
Well,
Page
no,
of the,
I would like that back, but I would like to ask him a question when it concerns that.
So you want it back, or do you want him?
No, I want him to look at it and I want to question him about it. But once he's done with, I'm going to be questioning him. I would like that back, take it back. That's all. Okay. Okay, you see the part right there where it says evidence officer. Can you tell me what that says?
None.
None. So how did you move forward if there was no evidence?
Mr. McCreary, you established what it is.
Oh, okay, that's the, can you read that for the record, sir, at the top of the page?
Well, actually, you would have to ask questions. That's
Oh,
what I
okay.
know.
Can I see yours, Mr. Prosecutor? What are you gonna gas at?
yes.
Okay, you have in your hand what's called a Detroit Police request for a warrant, am I correct?
Right.
Okay, on the top part it says admissions and confessions. What does it say?
None.
Really, I don't normally cover chili because I don't need to be involved in that nonsense. I've already been sued by one crazy fucker. And one, by the way. But anyways, I am not up to date on Chili and his nonsense. But I'm guessing you're talking about his Las Vegas case, and I probably should know. I'll call Alex and see what he knows, because that's my Nevada hookup. Anyways, let's get back to this crazy sob sit. Since he handed in his sob sit card, does that mean he got rid of the trifold? Or is he still trying to peddle that trifold for the masses for, what is it, $5 or something for his indestructible trifold? Can I get some defamation shamrocks in the chat? Or something. I don't know.
Okay, lineups, what does it say?
Single photo lineup showing Mr. McCreary.
Okay, evidence.
None.
Okay, and then you have the witnesses, then it says video. Can you tell me what that says, sir?
Body worn camera footage not available to report being taken at the test.
Okay, and photo.
None.
Okay. So is this typically how the 10th precinct operates? No warrants,
Ooh, he
no
upped the
evidence,
price.
they prosecute individual citizens. Is this how this happens, sir?
So when I submit one of these,
That's a question, sir. I'm asking the question.
yes, this is
Yes, no.
typically what ours looks like. We send it in.
No, what I'm saying is this the procedure or the custom that your agency uses when they prosecute citizens so far as no evidence, no warrants. I'm saying, is this a policy or a custom with your department?
One policy just,
No, I'm saying that the operating of procedures so far as handling of investigations, prosecuting citizens when they're accused of crimes. Is this how you typically handle cases with no evidence, no warrants? You go get people. I mean, is this typically how your department runs?
every case is different, sir.
Okay. Have you done this in your past history in Warren as well as Detroit, Michigan? Do you have a history of this, sir?
Sending you down warrants, yes, I have history.
Without evidence and without arresting people without warrants, this is what I'm saying. Do you have a history of arresting people without warrants or evidence, sir? This is the question.
I'm gonna object because
It
he's not,
shows,
Let him finish the objection.
he's
I could
already.
do defamation high five since
He's not
Michigan
around.
is a mitten.
Or have a warrant at the time.
well, what I was, just what I'm trying to establish.
So a rubber band costs $2. Okay, 5, 6, 7, 8, $3. I'm pretty sure you can buy like a whole ball of rubber bands for that much. Oh my god. These morons kill me. By the way, that's my opinion. Okay? If he's watching, I highly doubt it. I'm not on his radar. Oh, crap. Hold on, I gotta go back to that one.
Trying to establish way more than
Well,
what's needed for this exam.
well,
This
what-
is a whole, holistic type of approach you're trying to have here with the police department, Worthy, the bench, I understand that, but as far as this case, if you're not getting to specifics about what he did, it's not even seem to be that involved into what.
Well, what I'm saying is that right now, you had a chief judge that just heard my motion to deny me because they're your supervisor. He's the supervisor of these officers. They move at his direction. If they don't move at his direction, that means they're vigilantes, judge. They're just doing what they want
In
to
your
do.
opinion.
I mean,
So what is your next question?
well, my question is, does he have a history of arresting and charging innocent citizens without warrants and without evidence? And I know I
What's your
have.
answer?
No.
Next question.
Okay, I would like, now to establish that he's telling the truth, I would like to file a motion for the additional discovery under MCR 6.201, which allows us to his background history of complaints for false arrests or things of that nature. And I have transcripts before where this is already
Yes.
included
Yes.
in other court proceedings. And I would like to.
My husband wants to get a fez, and I was like, absolutely not. Now, his dad was a Mason. I told him, if you become a Mason and you join the Shriners, then you can get a fez. Otherwise, no, I will destroy it and throw it away. But he's missing his monkey hat today. But he's still performing like a circus monkey with his little cymbals. That's the noise they make, sorry. I'm pretty good at imitating noises, and you don't want to hear that nonsense. I've probably been down the rabbit hole. I just try to avoid it nowadays because I have done a lot of deep dives on these people, and there's the reason why I ignore them because I don't want to be involved. I prefer to not be on people's radar like that. If I'm going to be on someone's radar, I want it to be because I have good content or they find me funny or whatever, not because they're coming after me with some sort of vendetta. I mean, I've lived that once, and recently. I've lived it before, but recently, as far as like internet nonsense, I've literally survived that just last year. Actually, I think it was the beginning of this year is when the case like finally wrapped. I'd have to go back and look because there's so many documents and motions and requests that I have forgotten all of that. The thing is he's kind of one of those people. So, I've been down the rabbit hole, and it's just something that I'm trying to avoid because I never wanted to be dragged into it. But he did drag me into it. And now here we are. So honestly, if it wasn't for him, I wouldn't really have a channel because I used to just be a casual observer of some interesting cases on the internet. Now here I am with my own channel, which he's probably watching. So whatever. If you're watching, hi, go fuck yourself. Thanks. Bye.
Like to, at this juncture, subpoena his background history as to Warren as well as to Detroit, because if he has done this today to me, he has done this to me. And I would like the procedural and the substantive due process protection in this proceeding and the equal protection of the law of the 14th Amendment. Judge.
Denying that request. I know you like to object. Please object so we can move on.
Judge, I mean, I already placed my objection on being denied my rights to a fair trial.
It's not a trial. That's
not my trial. Well, this is a hearing. What I feel entitled to my rights in a hearing.
Cause hearing. It's not guaranteed by the Constitution. It's a statutory right.
Well, if there's a federal right, we have two different things, with all respect.
And I'm sure mine is right when it comes to whether or not you have a constitutional right to an exam or whether it's statutory.
Okay. All right, I'm ready with my question. Okay, so are you familiar with the law in Michigan so far as state statutes, state laws, and things of that nature? Do you have some form of did you receive some form of legal training when it concerns your job? You went to the academy back in the day.
Yes.
Okay. Did you know under MCL 750.505 misconduct offers that as a 5-year felony that you have committed against me, sir, based on lack of evidence, no more, sir?
I'm gonna object.
Well, the objection is not founded, Mr. Prosecutor.
Let him have his, what is it, I don't know his objection.
Relevancy, defendant's testifying, he's accusing of crimes,
Argumentative.
argumentative.
I know.
So the question just doesn't make sense.
Can I respond, please? I mean, he goes for purposes of impeachment, Judge. And then, like I was stating, Kwame Kilpatrick was sent to prison for the same thing that he's doing.
Do not bring up
And I
Kwame
mean, he's
Kilpatrick.
mayor.
You're not
No.
about to convince me anything,
That's fine.
mentioning Kwame Kilpatrick. So,
All right, well, I mean, can he answer my question? I mean, if he's a law enforcement officer.
For those that don't know, Kwame Kilpatrick is a former mayor of Detroit that did some really bad things. He was initially seen as like one of the better mayors for Detroit, but he was embezzling money from the city. It's been a long time. I know pretty sure he was convicted of embezzlement. And there might have been other lewd and lascivious things that he did as well, but I might be confusing some cases. Because there's a lot of corruption here in Michigan. But yeah, to bring up Kwame Kilpatrick like that is like, he had absolutely nothing to do with this case. And honestly, I'm pretty sure he had nothing to do with his earlier cases either, because I'm pretty sure it was before he was mayor. But yeah, and sorry, Jeremy, spam my channel around the place. I guess spam my channel away. I appreciate that. But yeah, to bring up Kwame Kilpatrick like that he's literally grasping at straws at this point. He has nothing. And I think Judge Sabri calling out that foolishness is absolutely appropriate.
Officer, he should have no problem answering questions.
well, it's not relevant.
Well, it's relevant because he's committed a felony, Judge.
That
Well,
accusation
It's-
has not been given to the court in any matter other than you telling him that he committed.
Well, can I again ask this court on the MCR 6.201 Brady versus Maryland?
Oh my God, not a Brady violation, dude.
For purposes of impeachment at People versus Stanway, which allows.
More discovery?
Yes, I would like to have more discovery so far as impeachment his witness because.
If this is found over, I will sign discovery order.
Well, I'm just saying is I need it for purposes of the exam under MCR.
Thank you, Jeremy. I appreciate that.
to
I really do.
Discovery is
cross-examine
an
this witness.
ongoing.
Well,
So today, the exam, if we're in the middle of it, there's plenty of time to prepare for this day. If it gets bound over, I will sign a discovery order, and you can request.
well,
Okay?
yes, ma'am. Under People versus Dayton, again, I say that citation I would have today in court with Judge Rosen dismissed a case against the prosecutor as a sanction for withholding evidence. He knew that his witnesses would be here, then he didn't.
That's an argument that you can discuss during the argument once addressed.
So he's not allowed to answer the question that I asked him so far.
No,
So,
I'm just saying.
okay. Are you familiar with Mr. McCurry or your department, the 10th precinct at all? Have you ever had any knowledge of him coming to your department or complaining about your department or anything to that nature?
For this case, I
What?
never had any contact.
Okay, are you familiar with the Sergeant Ball that worked at your organization?
Yes.
Okay,
Wait 1 second, sir. Is it the one that's retired or the sergeant?
He's retired.
Okay, so there's two balls there, the sergeant at some point, I just want to make sure I have the right one.
yes.
Okay.
Okay, so you did your investigation. How did you come about knowledge to McCray reside with his brother? How did you know how Mr. McCray looked? What information did you find out where he lived? Did you do a name check? Did you check the system for pictures or
Did he just
address?
refer to himself in the third
Yes,
person
sir.
for real?
So typically when I get a case, it pops up, we call it our hopper. It's where list all of our cases we got for the day. I make my initial calls, try to make contact with victims, you know, get them in for another written statement, because sometimes, you know, get a police run. People's minds are elsewhere, you know, people, you know, they don't ask the right questions. I might need more for my investigation. So I get them to come in, either me or someone else who might be used. I'll get a written statement from them so I can, you know, more of the story. That way, once I do send something like this over, whatever I get, I can put on paper and I send it over to the prosecutor. If they think there's probable cause to go forward, and then a magistrate thinks that, then it gets signed. If they don't, then I can only present what facts I have.
At your precinct, you guys have a warrant prosecutor? Yes. Typically, I remember from back in the day, you know, like they have assistant prosecutors available so that they can sign off and stuff like that. And that's relevant. He's one of the things.
Also, I'm gonna check the notes here.
Other than you establishing your argument that there was no warrant signed, what is your?
Well,
purpose?
I'm trying to show how his investigation came forth. Like, I mean, like, I know I've read things concerning Fourth Amendment. Fruits gathered after an illegal search and seizure are in court. And I'm trying to establish that. I remember from back in the day that they had prosecutors readily available that could sign off on stuff like that. Prosecutor didn't sign off on it. And
That
I'm
was
just
back
trying
in
to,
the day, not today.
Your objection is not relevant right now. You can put that in a motion if it gets bound over.
are you aware that Mr. McCreary, past and present, has come into your precinct and made complaints against your officer there?
Your brother Norman?
No, me, Colonel Michael McCreary, ill.
I'm gonna check.
All not relevant.
It's for purposes of impeachment, Judge. That's how it's
Everything
relevant.
you're saying is for impeachment.
People versus Stanaway. Stanaway laws.
It does not say you can impeach on anything. I know that case law does not say that. You can say anything in impeachment. That's not how impeachment works.
Well, I'm trying to show and establish retaliation by DE
Okay.
because of numerous complaints against them, because of recording them, putting them on YouTube, when they
Okay.
told an
So
officer
the
to break in the
officer
house.
on the stand doesn't know your brother, apparently, until this case is filed. He doesn't know you. So can we move on?
So apparently, not only is he a Moorish Savsit, he is also a frauditor. Fun. I think I need to find his channel. Hold on, we're going to continue watching this. I'm going to see if I can find his channel. I wonder what it's called. Does anyone know?
Move on to something else about what happened on the date and time of the investigation regarding you and your brother's complaint.
I mean, yeah, I objected again to this court's handling of this case. I had something in mind, but you proved me off. This gentleman here. Okay. Did you ever look at Mr. McCreary's picture? It was stated in here that you showed, or one of your officers showed Mr. McCreary, my brother Norman McCreary, picture. Is that correct?
Correct.
Do you know what picture it is? Do you have a copy of that picture here today in court? Because that wasn't in the discovery.
It's included in my packet. It's an open APA's office. It's the Michigan SOS picture, provided to me by the law enforcement information that we call lien.
And what came up in the lien? My driver's license, or what came up?
The Michigan SOS picture, yes.
Okay. All right. Your Honor, can I have the court officer show the prosecution's witness something
Your Honor, yes, you're a witness.
No, I have,
What is it? I don't even know what you're trying to do.
I'm laying the foundation. He's keep trying to shoot
What are
me
you trying
down.
to do?
I mean, I'm trying to figure out how he came in contact, how he came about. He just stated in here, so I'm gonna show my driver's license. Okay. Did you ever look at Mr. McCurry? And I object, right, to the denial of that. Did you ever look at Mr. McCurry's driver's license?
His actual license, no.
Who, which McCreary?
Me, I'm talking about me when I addressed me. Well, Colonel McCurry. Did you ever look at Colonel McCurry's driver's license when you
You're an evil
did the
genius,
investigation?
Pyramid.
Physical license,
Evil
one is your law.
genius.
Okay, but what I'm saying is in the system,
It wouldn't be your license, it would be the picture provided by Lee.
the picture by Lane. Oh, okay. Lane system, I didn't, okay, so, I believe on the paperwork, it says a CTN. What is that, a CTN, sir?
CTN.
A CTN, like on judgments, warrants, things of that nature, just says CTN, then it has ORI.
You asking me what a CTN is?
Yeah,
So that's gonna be generated by the system.
no, I'm saying you give me a breakdown and define what CTN.
Not something I deal with on my end.
Okay, may the people, attorney, since he always wants to object, could you tell me what a CTN means, sir?
He's not on the stand, dude.
I'm not testifying.
Okay, so you don't know the CTN, did you know that a CTN is?
I don't know objective, no.
I haven't finished.
I don't see the relevancy of the CTN.
I'm just saying is I haven't finished my line of questioning.
Well, I can't imagine what a CTN has to do.
Well, it's a cargo
Assault,
tracking
intent to
note.
murder. I'm sorry, what?
It's a cargo tracking note.
Okay. And that's not relevant.
Tracking note.
So next question, I know you objected to that as well. We'll place on the record.
So-
I have no idea what that is.
So you stated that you looked at my ID and whatever else in the link.
Right.
Okay. Did you know, that me, Colonel Michael McCurry, reserved his rights not to be, governed or controlled by city, county, state, federal officials? Well, I mean, it's relevant. I tried to establish relevancy.
Relevant to you, but it's not relevant to the case here.
Well, it's relevant because I'm not the strong judge. I'm not doing business with the corporation. This is what I've been trying to establish, but you're limiting my
I am.
defense. My
I am.
defense.
I am.
What about the motion so far as additional discovery to impeach him for?
What did I say?
I'm not gonna help.
What did I say?
And I have those
What
rights.
did I say?
You said after the fact, but I don't know where you will sign it.
For the record, the only thing that I found online about a cargo tracking note CTN has to do with actual freight and being on ships. So I'm not sure. Even when I searched the CTN with law enforcement, it took me to like border patrol stuff. So it has to do with cargo. I don't know.
Sign a discovery order, but I'm entitled to that to do a proper defense.
That's what I said. That's not gonna change.
Well, under federal law, the right to present a defense and the court is denied. So I-
No, they're not denying you anything, dude.
Okay, I mean, I can't question this guy because, this officer, because the court, the prosecutor keeps objecting, I'm being denied the right. to
Well, maybe because
defense.
you're not that great at.
I mean, I'm
Oh!
very well, I mean, I have a right
You're not
to.
that well versed with the courtroom.
Okay, I mean, I can't question this guy because, this officer, because the court, the prosecutor keeps objecting, I'm being denied the right. to
Well, maybe because
defense.
you're not that great at.
I mean, I'm very well.
Yes!
I mean, I
Judge
have a right
Reed
to-
points again.
Well, I fight the constitutional law, which you have ignored, which you have.
Definitely
too.
fight with.
Well, I'm just saying, under the Constitution, this court is bound by it.
I know what I'm about. Do you have any other questions?
I mean, I'm being denied, so I would just object, and then I would, once, if it's bound over, I would do a motion for a remand back to this court in front of a certain court with paperwork. And, you know, like I
okay.
said, I'm
I'll
in the
give you that
process,
one.
I should be taking that down and
Holy
coming to the
crap.
federal court. And I would like also to have this case removed to the federal court.
You have any more questions?
It's not a federal charge, dude. It doesn't get removed to the federal
No,
court.
I can't because I'm being denied.
Whoa.
Okay, any cross? No, you aren't.
Holy
Okay.
crap.
Thank you, Your Honor.
Any other witnesses or defense?
Yes, I would like to call the other witnesses listed on the paperwork.
And what did I say about that?
And you deny.
You bring us
I
a
said you do not
subpoena.
subpoena them or ask the prosecutor to make them available for you to interview them for the exam today. So they're not here, so you're not prepared to call them.
Well, can I just want to say this for the record, so just in case the higher court looks down the line at this.
Sure.
And like I tried to explain to the court, it was my intention based on the reading of the rule in the case law, it says even where you cannot show actual bias in the Supreme Court, that you would be removed and then I would have time to prepare these motions and documents.
You need to be ready to go when you're scheduled to go, dude.
Court as well as people who just admitted they have no warrants, they had no evidence. I mean,
Dude, you're railroading yourself. Like, this is all on you, man. The court's not doing anything other than calling you out for your stupidity and your lack of knowledge and understanding of Michigan laws. Like, you want it to be remanded to federal court? It's not a federal charge. It doesn't just get remanded to federal court. I mean, for that to happen, you would have to appeal it all the way through the Court of Appeals, then the state Supreme Court, then the district federal court, like the federal Court of Appeals, and then possibly the U.S. Supreme Court. But chances are you're not going to make it through the first round of the Court of Appeals to even be allowed to present your beyond your request for. Dude, you're doing this to yourself because you want to be a sob sit.
The higher court, that's what I'm at the district court level, so that's what higher courts are for. So they can address.
Circuit court's the next
Okay,
higher
well,
court,
maybe I
by
was
the
fine.
way.
Say something. Now, the law is clear. I mean, you took an oath under Article 6, Section 2.
Mr. McCreary, I don't want to hear about it unless it's about your argument in response to people arresting after they arrest. Well, actually, they arrest them. And you don't have any other witnesses present.
Well, I mean, I'm denying my witness.
You never
And
denied.
No,
You never denied. You had a witness list, you didn't contact, you didn't ask the prosecutors to provide them.
I didn't think
Or
this.
make them available for you to interview. Or contact them or subpoena them to come to them. This has been adjourned several times. That's the time to do so. I'd let you go to the library to research. I'd let you even go to the court to file a lien against my house.
I'm waiting.
I've done way more than I should have allowed you to do. So I am not going to adjourn this or provide a discovery request to you or grant that based off of you not being prepared today to call witnesses.
He filed the lien against the judge's house? That's fucked up. Like, I get it. That's how it works when you want to file a complaint or whatever. But seriously? Dude, you're not doing any of this properly and you filed the lien against the judge's house.
That were provided to you on a witness. So are there any other witnesses present today that you would like to call?
Well, I would like to respond if I may.
Yes.
Because you say I mean, I can't because I'm being denied.
Okay, so you don't have any other witnesses?
I mean, I have them. Yes, my brother Charles McCreary. I would like these police officers to be brought into court. Robert Vane, Diana Gerald. I have many other people that are willing to come into court and testify.
But why aren't they? If you
And
want
I'm
to
being
come there,
denied that.
today's the day,
I would
dude.
like
Today
to
is
again
the day.
clarify for the record that I didn't think that you would be moving forward because I was just in the court proceeding with Judge, what's her name? Where she denied the motion, then she sent it to the chief judge. Because from my understanding that if the judge grants it or denies it, then it has to send it to the chief judge. You never ruled granting or denying the motion per the court rule.
You accuse me of being biased, so why would I make a
I
decision?
mean, but what I'm saying is you
Why would I
could
make a
withdraw.
decision on
What I'm saying
something
so
where you're
far.
saying that I'm biased to you?
I'm about to
Yeah.
answer this. Like if you would have said denied, then you had to send it to the chief judge. If you would have granted it,
She
okay, we then
did.
send it for a blind draw. Per the rules and under people versus,
This is line draw, this is not trial. This is the exam stage,
I understand.
okay? So you don't have any further witnesses.
Well, I do.
Today was the exam,
I mean, I wanted them at the
you're
exam.
just not
Oh.
here because you did. Subpoena them, ask them to come, or ask the prosecutor to make them available.
They're not there because you didn't do the job.
Thank you, Your Honor. Your Honor, people move, find over
In my
on
opinion.
all charges. It's a matter of, it's a question of fact. We have one witness, that says that the defendant took shots at him, put him in fear for his life. Defendant is a felon, convicted felon.
Yep.
And therefore, he's not allowed to have firearms or ammunition. He attacked his own brother with bricks and a rifle.
Yeah.
And there has been no official testimony of him not doing it, other than the defendant during his objections or arguments or whatever they are, saying that I didn't commit a crime. It's a question of fact. It should be found over. And and the testimony was that it occurred in the city of Detroit, County of Wayne, so this court definitely has the jurisdiction under the court rules and the law to hear this and find this over. Cocaine at his own brother, he shot at him. We asked for a bind over on all charges.
First and foremost, I would like to object because by the officer's admission and the prosecutor knows fully well, there's no evidence, Judge. Not just that, the witness lying here in court today, and he's not credible. He stated that he never forged any signatures or whatever else. And I have evidence to show the opposite, that he's been perjured right here on the stand. Also, the burden is on the prosecutor. I'm innocent until proven guilty per administration of justice. Again, I admit.
So no, for a PCC, it's the preponderance of evidence, not innocent until proven guilty, or beyond reasonable doubt. So the fact that he is saying that he's wrong, and the burden of proof was his brother testifying, saying he threw a brick at his car a couple times, fired a gun at him, and missed. So yeah, that's the preponderance of evidence. He has provided zero evidence outside of him testifying without even putting himself on the stand. So anything like he's testified to doesn't count. So yeah, that's why you need a lawyer.
And deny these allegations. He's stating that ammunition, all that, where's the pictures of the guns, Judge? Like I stated before, where's the evidence at? Except my brother, who has lied in the past, and he has dishonest history, and he has a history of theft. And let me finish. I didn't object to. I didn't interrupt him. I'm giving my code. I didn't interrupt him.
I'm just gonna object.
He's objecting one
That's
thing.
fine. I didn't say that when he was talking.
We've been talking all day.
I'm gonna object because these are quoting facts that you try to get into evidence and they're not in it.
Mr. Sawaki, I know this.
Okay.
Objection on the record. Mr. Terry.
Okay. Under Opera versus United States, 348 U.S. 84, the Supreme Court held an accused extrajudicial admissions of essential facts or elements of the crime made subsequent to the crime are of the same character as confessions and cooperation by independent evidence is required. A, the requirement of cooperation applies to exculpatory statements to the same extent that it applies to incriminatory statements. The jury's finding in this case from the admissions of the essential facts together with all other evidence that the guilt of the petitioner had been established beyond a reasonable doubt is supported by substantial evidence.
Beyond a reasonable doubt is at the trial.
Okay, and I'm just reading this, like, to prove that the cooperative evidence need not be sufficiently independent of the statements to establish the corpus delicti. It is sufficient if the cooperation supports the essential facts admitted sufficiently
Need some sound set
to
bingo
justify the
cards.
jury inference of their truth, but those facts plus the other evidence must be sufficient to find guilt beyond a reasonable doubt. Now, I understand that this is just probable cause, but why waste the state's money and continue this ridiculous prosecution to proceed, Your Honor. They've admitted that they have no evidence. They've admitted that they have nothing but this man's word of mouth, who is in the community, is known as a liar and a perjurer. And I wanted to call Chief Judge Burtney, who's in Wayne County Third Circuit Court, to establish this, that he lied under oath, that he committed felonies. I mean, the prosecutor's office committed felonies, their witnesses committed felonies.
Everyone committed felonies.
So at this
You can find
juncture,
all of that at the trial, at the third circuit.
You get a felony. You get a felony. Everybody gets a felony today. Because everybody lies except for him. Ugh.
but again, I would like to object to this court's hearing of this exam for judicial bias, because under Kane versus MPOC, it says that even if I can show bias, justice teaches that the judge should recuse himself, because you have been the target of criticism and so on and so forth.
Only by you.
Okay, but what I'm saying is, and I've been arguing the law, and the court overruled federal law.
Hopefully with the pellet gun. So I thought guns are illegal in Ireland.
I researched it, and I've standardized it, and it's still good law.
So, okay. Mr. McCurry, you have made your argument and objected for the record. Would like to preserve that argument that there's no evidence presented today. What the court has to remind of is that testimony is evidence, whether you like it or not. I do believe that witness, Mr. Norman McCurry, was credible. And the burden of proof is on them. And they have to show at the probable cause standard.
Getty Westerns.
First, assault with intent to murder, that the defendant tried to physically injure a person, another person. There's testimony that the defendant, Mr. McCurry, tried to by not only aiming but also firing a gun at the complaining witness. Second, that when the defendant committed that assault, he had the ability to cause injury. In this case, he didn't have the ability. That was a deadly weapon that would definitely cause injury. And third, that the defendant intended to kill the person he assaulted, and the circumstances did not legally excuse or produce the crime. That would be a question of fact, the trier of fact as to the intent and what Mr. McCurry was doing. Pointing the gun, and I do believe in the probable cause standard, pointing the gun and shooting someone shows intent to kill.
Absolutely.
As far as the remaining charges, assault with intent to rape by the harm less than murder is lesser included, satisfied by the evidence of testimony. The count 3, firearm possession by the felon, has been established in Exhibit 1, in which Mr. McCurry was not eligible to the possession of a firearm, as well as count 4, ammunition in the weapon. Satisfied count 4, ammunition possession by a felon, and count 5, assault with dangerous weapon on his assault, has been satisfied based on the same testimony from the complaining witness, and of course the 4 accompanying weapons from firearm charges. So, Mr. McCurry, you're going to be bound over to Third Circuit Court, Framework College Justice, for your arraignment on information date of June 29th at 9:00 a.m. I do not know if it'll be on Zoom or if it'll be in person. It depends on which judge you draw. Anything else from Mr. McCurry?
No, nothing from those people.
Mr. McCurry, other than your objection?
Okay, so June 29th, he'll be arraigned in Third Circuit Court. I'm going to have to track it down and see who he gets assigned to, because it's not assigned at this point. Like she said, she doesn't know if it'll be on YouTube, so I don't know if I'll be able to catch it. I will try and get it recorded at minimum, because that's, hold on, I don't have my calendar in here yet. 29th, so that's in 2 weeks. So I'm going to try and catch that. If I can, I want to try and follow this case all the way through. Just because, I mean, it's an awful case. He tried to kill his brother. but his nonsense is absolutely hilarious at the same aspect. Like, yeah. So I'm going to try and follow it through.
Projections.
I would like to place my objections on the record because throughout this entire proceeding, I feel that this court has been biased when it comes to rulings. They've even allowed this prosecutor to use state law to supersede federal law, as stated in Cohen versus Virginia, that is considered treason with the United States Constitution. These are landmark cases. And also, you know, the witness lied under oath by stating he didn't do this, this, and that. And I mean, under standard due process, the U.S. Supreme Court held that no matter what rules you create, you must use fundamental fairness. Well, I mean, you asked me that anything else to sound.
Anything else? Anything additional?
Anything new?
I mean, I'm just fine, yo. And can I say one more thing?
No.
Again, like I challenged jurisdiction before testimony was even brought in.
And I deny it.
And, okay, but the law
Do you want the
mandated.
discovery order signed? Before I buy you over?
I mean, I would like all the officers, background history, Kim Worthy.
No.
Individuals here today, because it shows a pattern in history of felonies being committed in consent.
So what I'll
No,
do, I'll
sir.
sign this discovery order here, and if you want to expand it, new judges, if you get across the third circuit, you can ask for those additional things like 10 words. I'm not giving you that short order. I don't even know what that is.
Well, what I'm saying is so far, she's the chief officer of the county.
Yes.
And everything,
And I am not going to. do that.
and everything that her subordinates
I'm
do.
signing a normal
Well, what about the
court
bond?
scale certified discovery order for you to make sure that you have everything. Any video, it was mentioned that there was video possibly at the police station. This will give you that information, okay?
Okay, well, what about the bond? I mean, I didn't run, I'm not a runner. Why do you got this testimony? I mean, I can't get out of work.
Because you tried to shoot your brother.
I mean, I don't know what my brother said. I'm not trying to do that. This is a complete fabrication. Pardon?
I give you a lot of leeway. I'm going to continue
I have a right to.
Thanks for joining, Justin. I appreciate it. Have fun at work.
And the other option is within the Wayne County Jail with assault and attempted murder charges.
Yeah.
629 at 95. Okay.
Whew. All right. Okay. Let's see here. Okay. Let's take off my fez. Starting to give me a headache there. Now, let's see. Who do we want to watch now? Let's go check out Judge O'Brien. Ooh.
Good afternoon, Your Honors.
Want that at 1:30 or 3 o'clock on the 21st?
La información para contactar el departamento de.
Oh no.
June and July of 1995, and that you last reported to probation May 8th, 1995. So, Mr. Vincent, how are we proceeding?
My client will stay in mute to the charges. We asked for a hearing date, and Your Honor, we just have been retained. Obviously, this case is nearly as old as I am, 23 years. So I need an opportunity to get into the case to see if we could work something out to make this thing kind of go away from Miss Gardner. She was a very nice lady. Her daughter's here in the courtroom supporting her.
Okay. Mr. Dobie.
Is there a recommendation from probation?
There is not. We had to do some scrambling and create a file. This file was, open back when we still had road notes. So yeah, no, I have no recommendation, but I will note that I didn't find anything new in running a lien. So I don't have an objection to any kind of a PR bond, but I would like for Ms. Gardner to contact me and give her my phone number and stuff so we can touch base.
Then I have no objection to a PR bond and adjournment.
And
Okay.
Your Honor, I'll make sure that gets done. So we contact.
Okay. Do we have her current address?
I have, the address I have is 380
Good afternoon.
Ohio Street, H-O-I-O, Ohio Street, Ypsilanti, Michigan, 48198.
And is your client employed, Mr. Vincent?
We could not hear you, Your Honor.
Is your client employed?
She has an awful
She
microphone.
is retired, Your Honor.
Okay, but she has ties to the community.
Yes.
Okay. Will she agree to contact probation following this hearing?
You'll do that, right, ma'am?
Yes.
Okay, then I will grant a $1,000 personal recognizance bond. When would you like the next hearing, Mr. Vincent?
Kelly's going to tell me in about 2 minutes. Your Honor, they won't let
Brain
me
trust.
schedule anything.
Your Honor, while we're waiting for that, can I also get her phone number? I'm okay if Mr. Vincent wants to send it to me like in the chat. I don't,
Yeah, we'll do that.
okay, or email is fine. That'd be great.
I can go for it.
Is June 29th all right, Your Honor?
June 29th would be fine at 2:30 for the violation hearing.
1:30. Yes. At 1:30.
2:30.
By Zoom.
2:30 by Zoom. Okay? Okay,
Thank you, Your Honor.
you're welcome. We'll see you then, Ms. Gardner. It's important that you appear for that by Zoom.
Okay, thank you, Your Honor.
You'll be released from the jail a little bit later on, okay?
Okay.
Bye-bye.
Bye.
There is someone on my docket who is in a moving vehicle. Please turn off your video. It's distracting to the court to watch a video of a moving vehicle. And you have to understand that when the case that you're involved in is called, the vehicle must be stationary. I cannot do a hearing with a moving vehicle. Thank you.
Okay, it was an attorney.
Supplemental number 3, People versus Paul Van Slambrook, 20343 FH.
So we just finished that case.
Good afternoon, Your Honor. Kenneth Overwater,
yeah, I
Assistant Public
rewound this.
Defender, on behalf of Mr. Slambrook, Van Slambrook, who is present by Zoom.
We just finished the Moore case. He got bound over to circuit court for his, I guess he still has to be arraigned or whatever. But if you want to rewind back to the beginning, that starts the case. We're just watching, seeing if there's anything fun happening anywhere else this afternoon.
Mr. Van Slambrook, would you turn on your camera and unmute your device, please?
Yeah, sorry, I'm see, there we go.
Okay. Good afternoon. And from the Attorney General's office.
Good afternoon, Judge Carrie Angie, appearing on behalf of the Attorney General.
Good afternoon. So today's the time and date set for the pretrial. How are we proceeding, Mr. Overwater?
No, I'm going to be asking for an adjournment. Mr. Van Slambrook was arraigned on Tuesday, and Ms. Ainge and I were not aware until earlier this morning that he was added to today's docket. So we spoke, but we haven't had much in the way of substantive conversations. So if we could adjourn this out, I would ask for, if I could get July 13th, that will give Ms. Ainge and I time to find out where we are in terms of arrearage and a payment plan to resolve the matter.
Oh, boo, a child support case.
Ms. Ainge?
Honored.
Distributed to apprise
Full was here fusion moving forward.
Seven.
Man.
Michael Dobie for the people.
Good afternoon. Mr. Sanders, please raise your right hand to be sworn.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
Can you state your name, please?
Demetrius Sanders.
Thank you.
Mr. Sanders, a demand has been made by Lucas County, Ohio for your surrender for the crime of possession of cocaine. You have the right to demand counsel, and you do have counsel appearing with you today. You have a right to issuance and service of a warrant of extradition, and you have the right to obtain a writ of habeas corpus. If you want to test the legality of your arrest, I can set a reasonable amount of time to allow you to apply for that writ of habeas corpus. Mr. Tuttles, have you been able to speak with Mr. Sanders?
Yes, Your Honor. Just so the court can be aware. And Mr. Dobie, I'm not sure if you were the person who had contacted Lucas County before, who indicated they did not desire Mr. Sanders to be held, or they wasn't, and they were not coming to get him. Are you the person who had worked on this before with me?
No, sir.
Okay. All right. So, Your Honor, we'll revisit. This is a revisit matter. We revisit this, or we visited this matter before, and there's some other proceedings going on with Mr. Sanders, and I believe his parents just post bond either probably yesterday, and because the warrant is just still showing in the system, that's why we are here now. But the way I think we should proceed is we allow Mr. Sanders to post bond, and it's a violation of probation in Lucas County. It's not a new charge. It's a violation. He was on probation. He picked up a case here. He's been in Washtenaw County now for more than 3 weeks. So I think we should you allow Mr. Sanders a bond, give him a date to come back to this court to indicate he has gone down in Lucas County to address the issue there in Lucas County.
Mr. Dobie.
Yes, Your Honor, I do see that back in March, there was a message from Lucas County that they would not proceed with extradition at this time. Now, of course, the procedure here, once someone is arrested, the Sheriff's Department will check with that county and hold someone if there is an indication that they want to extradite him. So I have no contrary information that they do not want to extradite him at this time.
And
so
as to the bond, go on.
Yeah, I think we proceed with the normal procedure, if you waive or not. But as to bond, I ask that the defendant be remanded.
And
I apologize, Your Honor. I'm not sure why Mr. Dobie is asking that he be remanded when he's seeing in the computer that someone in Lucas County, the appropriate authority in Lucas County, said they don't, and they're not desirous of coming to get Mr. Lucas or for us to hold Mr. Lucas. They understood at that time that Mr. Sanders was getting a bond and was going to be free, and they said we have no desire to come and get him. So why would we remand him when they've indicated? I don't think that anything has happened between the last time we were in court early March and the day that we were in court today. In all honesty, Mr. Sanders is in a better position today than he said back in March, because the only matter that he has now is a possession. When in March he had a armed robbery, but that was dismissed. He had a felonious assault, that was dismissed. So he only dealing with a possession matter now. He's still in a better position than he did then.
Yeah, I think that the difference is that that our local charges are no longer pending.
Well, that would be to Mr. Sanders' benefit. So I don't think a remand is appropriate.
Mr. Doby, do you believe that a bond is even appropriate in an extradition matter?
I don't, Your Honor. I don't. It is prima facie proof that he has fled from that jurisdiction.
No,
He
no,
had
no,
pending
no, no,
matters
no,
here.
no, no, no,
I
no,
don't
no,
know
no,
if
no,
that
no,
would-
no, 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 no. Just because there's a order for extradition. Sorry, my mouth got dry there. An order for extradition does not mean that he fled that jurisdiction. He's apparently on probation out of Lucas County, Ohio, but he now lives up here. His probation violation is the underlying charge that has landed him in Washtenaw County. So he's not fleeing the jurisdiction. That is not what that means. That just simply means he's not in the jurisdiction and they're wanting him to potentially come back to deal with his probation violation from their court. So no, an extradition does not mean that he's fleeing jurisdiction. That is absolutely not what that means.
That played into the other county not getting him, but those are now resolved. And I believe the only thing pending now is this extradition back to Ohio, and granting a bond and saying that he will self-extradite does not seem like a appropriate procedure.
And when Mr. Doby say fled, he has not fled. He picked up a case in Ohio in Lucas County a couple of years ago, and they put him on probation. Then he come back to Michigan. That's where he's a resident of. And then he picked up other cases. And because he picked up the other cases, that's a violation of his probation. So he has not fled from Lucas County. He come back to where he resides.
Apparently, this prosecutor doesn't ever go anywhere outside of his home county.
It indicates that they said we're not interested in coming to get Mr. Sanders.
Well, that may have been the case in March, but is there any recent information, Mr. Doby?
No, Your Honor, only that the procedure is that when he was arrested on this, they would have checked with the issuing agency.
So as to waiving extradition, Mr. Tuttle.
Yes, we would waive extradition.
Okay. So, Mr. Sanders, have you been able to consult with your attorney about whether you should waive extradition or not?
Yes.
I'm sorry, I didn't hear you.
Yes.
Okay. And he says that you want to waive extradition. Is that correct?
Yes.
Has anybody threatened or coerced you to get you to waive extradition?
No.
Has anybody made any promises or inducements to get you to do so?
No.
I'm sorry, no. So you're waiving extradition after consulting with your attorney of your own free will?
Yes.
Okay. Satisfied, Mr. Doby?
I am.
Okay. So I will sign the waiver of extradition after Mr. Sanders signs it, and we'll give the authorities 14 days. If they don't pick him up, then he can be released. Okay?
Sir.
Oh, do you have the papers there? If you would sign that, sir.
You see a unicorn.
Okay, and then as soon as I get that, I'll sign it as well. Good luck to you, sir.
I have a question, Your Honor.
Yes, sir.
Yes. Are we coming back in court in 14 days, or is that release after 14 days automatic?
It'll be on the order that he can be held for 14 days. And if they don't pick them up by then, they'll have to go back before another judge or me within that time. Okay?
So, yes, just for clarification, so after the 14 days, he's still in custody, then we have to schedule a date to go in front of a judge, which might take another week.
You can get him on the docket on an urgent basis. We do arraignments every day. So you are remanded pending that extradition. Good luck to you, Mr.
I
Sanders.
don't like that. I don't like that one.
You're welcome.
Yeah, thank you, Mr. Dovey.
Thank you.
Number 5, People versus Mylan Patton, 22166 FH.
Sorry, I'm trying to get on more often, you guys. Been dealing with health stuff.
Good afternoon. I'm at work. I'm sorry.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Patton. Ms. Patton, you're going to have to sit down and pay attention to court. Otherwise, we're not going to be able to do this.
Okay. Right here. I can see it.
Good afternoon, Judge. Carrie Angie, appearing on behalf of the Attorney General.
Good afternoon. So today is the time and date set for the final pretrial. We do have a jury trial scheduled for July 10th.
That's correct, Judge. We've reached a resolution on this matter by which my client would plead guilty as charged. We have a Killebrew agreement for a sentence of probation with no additional
I've never heard of
jail.
Killebrew.
Unfortunately, my client was not able to reduce the arrearage to the amount needed for a delayed sentence. But as the court can see, she's working and payments are being taken from her check. Her parenting time has been adjusted by Judge Vandenberg, and she is getting more time with her children and continuing to work out to adjust her current obligations, which hopefully will allow her to direct more money towards the arrearage.
And is that true, Ms. Ange, in terms of the sentence agreement?
That's correct, Judge. I am, in exchange for the guilty plea, I will be recommending no upfront jail time.
So, ma'am, please raise your right hand to be sworn. Your right hand. Please raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Can you please state your name for the record?
It was Milan Patton, but I changed it, so now it's Milan Rose. That's my maiden name.
You know, the audio is not good quality. It's very difficult to hear you.
Can you hear me now? I'm sorry.
Well, it kind of sounds like you're in a tunnel. Try and keep your voice up. I understand that you're at work, and I don't want you to be distracted by other things going on around you, because this is a very important proceeding. Do you think you can give sufficient attention to this?
I can. Can you hear me?
Very, very minimally. Is it sufficient to create a record?
I did not catch her name, but I can hear the rest of it.
Sorry,
Okay.
guys.
Apparently, we didn't get your name on the record.
Milan Patton.
There we go.
Okay. So can counsel hear her?
Thank you. I had
Yes,
never
Judge.
heard that term before.
And if you could turn up our audio. So your attorney says that you want to plead guilty to this charge. Is that correct? Have you had sufficient time to consult with Mr. Overwater about what to do here?
Yes.
I need to advise you, ma'am, that failing to pay child support is a felony punishable by up to 4 years and/or $2,000. Understood?
You're licking my glass.
There are a number of rights that you'd be giving up if you enter this plea. You have a right to a trial by a jury or by the court if all parties agree. You have the right to be presumed innocent and to have the prosecutor prove you guilty beyond a reasonable doubt. You have the right to have to call witnesses to testify to see, hear, and question those witnesses, and to have the court order that witnesses appear for your trial. You have the right to remain silent and not have your silence used against you. And you also have the right to testify if you so desire. But if you entered this plea today, you would give up all of those rights. There would not be a trial, and the Attorney General's office would not have to prove any of these allegations. Do you understand all of that?
Yes.
And do you still want to enter this plea today?
Yes.
So at the time of this offense, and it actually covers the period of time between March 1st, 2019 and March 31st, 2020, were you on probation or parole?
No.
Are there any potential immigration consequences, counsel?
To my knowledge, Judge.
None that I'm aware of, Judge.
Okay. Are you entering this plea of your own free will?
Yes.
Has anybody threatened or coerced you to enter the plea today?
No.
Has anybody made any promises or agreements other than what was stated in court today?
No.
Are counsel aware of any promises or inducements or threats not on the record?
None, Judge.
No, Your Honor.
So you're
Okay, we're gonna switch over to
Doesn't sound like anyone I represented before.
That sounds
Judge
fabulous.
Middleton's courtroom.
But I can't say 100% sure.
Run the
Go over
eyes.
to Judge
Had to
Middleton.
pull out.
You know he's got to
Yeah,
have something
randomly.
good.
Randomly picked, if you're cool with it.
Okay.
AKA, do it. AKA, a buy lunch.
AKA,
Oh,
You picked a restaurant.
hold on.
Conflict we need you for.
Okay.
Got to turn up the volume for
Sound like
Middleton.
anyone I represented before.
That sounds fabulous.
But I can't say 100% sure.
Run the
By the way,
eyes.
Shago Pop's
Had to
awesome.
pull out. You were randomly.
Hey, Ironton Auditor, how are you today?
Okay.
AKA, do it. AKA, a buy lunch.
You picked a restaurant.
I don't know what
All
a
right,
man
good
puff
afternoon,
is.
everyone. We're about to deal with one more.
I don't know what that
matter.
means.
We did not have any final pre-trials today. Judge Patterson did. And
Just
we'll
put in
have
like
some
my
things
name
on
and
the
address.
Yeah, just your name, feed number or something.
Okay.
I'll give you everything.
All right.
Guys,
waiting
I'm
for-
screaming while
You
I'm
guys done?
dealing with my lavender
Oh, you're all
harvest.
right. You're all right. Turn a record on. This
I'm
is
doing
file
okay today.
23891FY, People versus Anthony Sandoval. Mr. Sandoval is at the St. Joe County Jail, connected by a Zoom link. The telecom connection.
Oh my gosh,
Attorney Paul
dog.
Gibson is here with me. David Marvin emailed us earlier. He won't be attending. We were here Tuesday for a pre-exam conference, and Mr. Sandoval wanted to have more time to discuss. the plea
No,
offer
it's just
with
reflective glass,
Mr.
like a
Gibson, and
film.
I think that probably had some merit. So Mr. Marvin agreed to extend the plea offer until Friday noon. And Mr. Gibson went out to the jail, had an opportunity to meet with Mr. Sandoval. Mr. Sandoval, they're going to reduce the felony charge of, domestic violence, third or subsequent offense.
Oh, no.
As
No. I'm not okay with that.
charged, which is a felony punishable by up to 5 years imprisonment and a fine of up to $5,000. The
Sorry, I
allegation
don't
is
agree
that
with
on
that.
or about April 9th that you assaulted Maria Hernandez, someone you had a dating relationship with. And there
She
were at
left
least
him.
2 previous convictions, making it a third offense. Mr. Marvin, the prosecutors agreed to dismiss that charge
Oh my gosh. my
for a
dog.
plea to domestic violence second offense. He asked that I not do a sentence today. He asked that I get a pre-sentence investigation and input from Ms. Hernandez. Mr. Gibson, is that your understanding?
Yes, Your Honor.
And did you go out to the jail and discuss that with Mr. Hernandez?
Yes, I met.
Okay, this is probably an unpopular opinion, but if someone is charged with their third DV, I don't think they should be allowed to take a plea unless they're pleading guilty to the charge, because that's bad. Like, seriously, your third one, and it sounds like it's not the same victim every time. Like, that's even worse. That shows that you have a pattern of behavior, and I don't think you should be allowed to take a plea deal for that. Sorry, I don't.
Mr. Sandoval?
I met with him yesterday, yes.
Anthony, are you going to plead to the misdemeanor charge of domestic violence second offense?
Yes, Your Honor.
All right. You and I have had this discussion before about what the rights are, but let me go through
also
them
with the
again.
DUI.
Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Especially when the DUI, like, they're pleading down to, like, no ops or allowing an improper person to use your vehicle or whatever. That, no. You need help. You need some Jesus or something in your life. I don't know. You need something. You need help. When it's your third offense for that type of stuff, no. I'm sorry. That's why we have a 3 strikes law here in Michigan. Unless there's like significant time, we're talking like 10, 20 years in between, and you've kept your nose clean, then maybe I can understand pleading down to a lesser, crime. But for stuff like this, no. Absolutely not. It should not be allowed to plead. And I get it. He's only pleading down to a DV second. But still, that means the next time it happens, they're going to be like, oh, it's only been twice. So no, I don't agree with that. I think it's wrong.
Yes, Your Honor.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Gibson has been appointed to represent you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand yourself and testify, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury cannot hold your silence against you. And you have the right to be presumed innocent if and until the state was able to prove your guilt beyond a reasonable doubt. Other than this misdemeanor plea agreement, anybody promise you anything to get you to plead to this?
No, Your Honor. I chose under my own will.
Yeah, because you don't want to go
threaten you?
to prison for 5 years.
No, Your Honor.
All right, well, let's talk about what happened back in April. Let's take a look at this amended complaint. In April of this year, were you living in Sturgis in your same house on Ohio Court with Maria Hernandez?
No, Your Honor. We live in 300 North Street, apartment 3. We've been living there for a couple of years now.
All right, wrong address. So this is where that happened over on North Street?
Yes.
What time of day was it?
As far as I recall, I believe it was around 8 in the afternoon. I can't remember that far.
Well, this says not 10:30 in the morning.
Little bit of a difference.
Had you been drinking?
Yes. During those issues, that's when I was drinking that night. Yes, I was intoxicated.
All right.
See, that is actually like makes sense. There is a significant underlying cause as to what happened. You were having seizures. You can't exactly help having seizures. That's not something they're hard to control. Even with medication, you can still get breakthrough seizures. So, there are instances where being able to take a plea makes sense. for me, if I were to have a diabetic, emergency when I was driving and I crash, if my sugar was too high or my sugar was too low, because when my sugar gets high, I lose consciousness. If something like that were to happen and then I'd be able to plead out, like that makes sense. But just to be able to plead down for the sake of a plea, no. I get it. I know trials cost, but I mean, we're looking at the safety of the public. If he's willing to hit his girlfriend, dude, if someone pisses him off, like at the bar, he's just as likely to hit somebody else. Or maybe he hits women because he's a coward and that's who he goes after, is the weaker person. But I still have a hard time with plea deals. Pleading from a third TV to a second DV, no, I don't think that's okay. Yeah. Yep. But that makes sense, that you have to be able to prove your case. So, I mean, it sucks that it happened, that you were, I'm assuming, in some sort of an accident. But yeah, there's a difference. Hey, Georgia Peach, I see you there. You kind of came in right in the middle of a rant. I'm talking about, people taking plea deals for lesser sentences when they're, it's their third or fourth charge of a similar violent charge. So that's what we're talking about right now. We already covered the other one with Judge Supri.
Did you get into an argument with Ms. Hernandez about using the car?
Yes. Due to the circumstances, I was intoxicated. I was trying to get a hold of the car, which she didn't let me drive because I was intoxicated.
Because you were drunk?
I got a little upset and I was trying to take the keys away from her. Then that's when the cops got involved, when she called 911.
All right. So did you pull her hair or push her off the couch?
As far as I remember during that day, she was laying down and then I was trying to get a hold of the keys, which she had in her hand, and I might have accidentally, at the time of me trying to take the keys away from her, might have slipped my hand, and I would have probably, as far as I can remember, I might have accidentally physically abused as I was trying to take the keys away from her.
Put your hands on her to try to take the keys. Is that correct?
You don't accidentally physically abuse somebody.
Yes,
I'm sorry.
to give me the keys.
All right. Mr. Gibson, are you satisfied with the factual basis?
Yes, Your Honor.
Thanks, Terry.
All right. Mr. Marvin asked that I get
Certainly appreciate you stopping by.
I don't know how feasible that is. It might be easier because you were just on a probation. You've been in custody now.
He just was on probation? Oh, my Lord.
$16 days. You most recently were on probation in 2022. No, you didn't do a probation. You were on probation in 21. Who was your PO?
I don't recall my probation officer.
Daniel, Matt, or Autumn, do you remember?
Yeah, I think that's what his name was, Daniel.
Daniel, all right.
Gosh, my chair is driving me bonkers. Hey, don't bark.
Underlying each one of these is the fact that you've been drinking. There's a lot of assaultive behavior going back to when I first met you back in 2014. And almost every one of them involved alcohol. And the last 3 of them involved Maria.
Well,
something bad is going to happen. We tried anger management.
Then.
and domestic violence class. That didn't work. It was revoked. Then we just tried jail.
Maybe he needs prison. Obviously.
This time I actually want to turn my life around. I want to go into a program, probably
Oh, bullshit.
some type of CMH program. As far as I know, when I get into drinking, that's when the problems start.
Yeah, I agree with you. You say you did do a CMH program or you want one?
I want to get my life together. That's the thing about me drinking. I want to join a program where I can be assured that I can completely stop drinking. I've been thinking about.
That's up
Well,
to you.
it's hard work. There's no magic bullet.
Oh my Lord.
To make you just stop drinking. One of the problems
there's
is
drugs
we've
like
got a
cannabis.
busy several weeks.
There are
I'm gonna
medications,
set this for
but
sentencing. Paul, does Thursday, July 6th at 10 work for you?
Yes, absolutely.
Thursday, July 6th at 10?
Yes.
Yes.
yeah, I wish it worked that way.
All right, I need victim input,
Save a lot of pain from a lot of women. Myself
police
included.
report, input from probation. PSI on short notice. Bond is canceled. Mr. Sandoval, you've had some clean time, 16 days of no alcohol, no drugs, to kind of get your head on straight. You've got a good proposition to try to get things turned around, but you got, by my count, 1, 2, 3, 4, 5. This is your 6th assaultive offense, plus some other drinking related offenses. The good news is this insulates you from a felony conviction for this, but we got to figure out what
no,
to
I
do.
shouldn't be allowed.
So it's set for Thursday, July 6th at 10 o'clock. We'll get more information. We'll have you brought up to the courthouse. Mr. Gibson will stop and meet with you before that. And in the meantime, your bond is canceled. All right, I'll see you on July 6th.
Well, that protects Maria for a little bit longer at least.
Thank you, Paul. So obviously no PEC is needed for next week, no prelim needed.
So
Yeah, I
Maria's
did meet with
for a little bit longer.
So it looks like we just have one that's still on for Tuesday. So.
Well, the
man, oh man, oh man. Let's watch some arraignments or something. Maybe something crazy's happening in arraignments. Come on.
You want me to hold this file until I do the female co-defendant, or do you want the papers now?
Hopefully we can hear.
Here we go.
Hear the prosecutor.
Hi, what's your name, please?
Keon Bacher.
Okay, good afternoon. This is case number 230-448-0201, people of the state of Michigan versus Ahmed Bacher. Counsel.
I thought he said Ken.
Thank you, counsel. The court notes formal reading has been waived. Interest are not guilty plea on your client's behalf, and I will hear arguments as to bond.
A misdemeanor, however, the people are going to be asking for a $5,000, 10% cash bond.
Ooh.
If the defendant were to make that bond, judge, we would be asking for some type of monetization. Here, there is a high likelihood of conviction, Your Honor. There is video footage, not just that, Judge, it's the severity of the incident. I'm sure Your Honor has gone through the investigative report As a result of what this defendant ended up doing, and mind you, Judge, it was innocuous up to the point where allegedly the defendant ended up getting aggressive. He allegedly ended up putting his hands around this individual's neck. He ended up striking her, which caused allegedly this individual to hit the ground. Ultimately, Judge, when the police are investigating it, interviewing this gal, she ends up having seizures, and she has to go to the hospital. Judge, Your Honor, again, I know this is a misdemeanor. However, this is
no, he needs to be charged higher.
Again, there is a high likelihood of
holy
conviction.
crap.
There is video to substantiate this. The people do feel as though this defendant is a danger, and we justify in asking.
Now we have people being undercharged.
Thank you.
What is going on?
Defense counsel.
Yes, Your Honor. 32-year-old life lived along 2 cases out of 32 years life.
By the way, I still have, I don't know, can you guys see this? I still have like a full basket of lavender to harvest. So, I mean, you're more than welcome to stay with me. I'm just going to be watching, so I'm just going to stream while I watch whatever. This is what I normally do. When I'm not live streaming, I just bounce between the courtrooms and watch stuff and, I don't know, see if there's anything good that I like to record and report back. But for now, we're just going to keep going until someone says no more, I guess.
Like he has no prior criminal history, not on probation of parole, and no communication. He is employed, but after expenses is below 200% burden guideline, TMI for my client. Respectfully, I do understand this is a sort of allegation. But as stated before, my client.
Yeah, he needs to be charged with assault, great bodily harm.
Okay. To the people, what do you know about this security guard's presence still at this location? Is she still working there? Is he likely to come into contact with her if he's at that location? This is where he lives.
Right. If we're talking about a no contact, in full candor, Judge, I don't know.
Okay.
The position of the security guard.
Damn.
All right, so this is alleged to have occurred on June the 4th.
Someone's getting
Says the
spicy
police saw him coming out of that location June 13th. That's when they arrested him. And I'm not hearing anything happening in between that time. I'm tempted to do a tether here, but I'm concerned that a tether is still going to keep them in contact with each other. And so help me understand the request for bond here. Is it that you believe that if he's out, he's a danger to her? Or are we ensuring his reappearance?
Because as defense counsel pointed out, there isn't a history. I mean, we don't have prior convictions. This is an isolated incident. It is a misdemeanor. It's just the severity of this actual attack. And then subsequently, what ended up happening, the head and the seizures and everything else, that it did just at least clearly show to the people that he was a danger if he would do something like this particular instance, which seemed like it was a nothing thing up until what had happened.
Mm-hmm.
In terms, Judge, in terms of asking, it's the danger. It's not the flight. I can appreciate what Your Honor is going through in terms of this because of the close proximity, and the people can't tell whether or not. I know that there was some time in the incident and within the arrest. I mean, Your Honor, I do know that the officer had to go to the hospital. I don't know if that's what it took. And I hate to kind of beat around the bush with the other, but we don't know. We don't know the status.
Okay.
The only problem with the arraignment court is we get these silences.
All right.
which I normally edit out.
Bond is going to be set in the amount of $150,000 personal.
Yes.
Mr. Bacher.
No!
There will be a no contact order here with respect to this security guard.
Ugh.
What that means for you is if she's still
Personal?
working at the building, you got to go somewhere else because you're not going to be able to avoid violating the court's order that you do not have contact. It would bring you too close in proximity to the guard. So if she's still working there, you'll need to go somewhere else. $150,000 personal. No contact with this complainant, meaning no verbal contact, no written contact, no contact with third parties or social media. Any attempt at contact would be considered a violation of the conditions of the bond. And as I said, I'm not going to tell you you cannot go home, but if she is still working at the building, then you cannot go home. You will need to find somewhere else to go.
Ooh.
All right? All right. Next court date. Going to be in front of Judge Bryant, August the 16th for your pretrial. Thank you. Okay.
I don't know, Jay Green.
Wow. Can't go home if she's there.
Hi, what's your name, please?
Mandel Wilbur Barrett.
I don't know how I feel about that. You know, sitting in this for a second, it's her job, but he lives there. So if she's working, he's not allowed to be there. So what if he's home and she comes on duty? He has to leave? That's his home. It's her job. I struggle with this one. I understand I think he should still be in jail. But to say he can't go home, it's a non-domestic. That he can't go home because her job has her working there? I mean, it wouldn't be fair if she lost hours, but I mean, if she's still having seizures anyways, should she be doing security? I don't know. And Jerry, you're right. You know, at least he said he kept his mouth shut. That's probably the best thing he could have done, was just kept his mouth shut. But I don't know how I don't know. What do you guys think about that? That it's, you know, a no contact, but if he goes home and she's there, he has to leave and can't go home. That's kind of fucked up. I don't know. What do you guys think about that one? Yeah, she might be on workers' comp. I don't know. I just think that's kind of odd that he's not allowed to go home if she's there, but it's where he lives and it's where she works. So that is kind of odd. That is weird. And he can't even like contact her employer, be like asking her to leave, because that's like third party contact. So yeah, that's really messed up. I don't like that.
All right, Mr. Berryman, you have some traffic misdemeanors where you missed court dates. When you missed your court date, the judge assigned to the cases, issued warrants, they set bonds. We're going to set the warrants aside today and give you personal bonds on the tickets. You do have the right to remain silent. You're being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on the tickets. If you can't afford an attorney, one will be provided for you on or before your next court date. These are misdemeanors for which the maximum possible penalty is up to 93 days in jail and or a $500 fine. Ticket number 701370 alleges January 10th of 2022 at Huber and St. Cyril that you had no operator's license and no insurance. 473262 alleges February 8th, 2018 at Harper and Meringue, no operator's license. 495728 alleges July 11th, 2019 at Charleston, Nevada, no operator's license. P1147597 alleges December 28th, 2020 at Chrysler in East Warren, driving while license not valid, driving an unregistered or untitled vehicle and no insurance.
Oh boy.
P1171662 alleges March 3rd, 2021 in the area of Connor and Charlevoix, driving with an expired driver's license. And P1382737 alleges August 24th of 2022 at East State Fair and DeQuinder, driving while license suspended and no insurance. On all of these, sir, you will have the same court date and the same judge. You'll have pretrial July 21st in front of Judge Yancey. Now we'll go to your other matter, which is case number 230-573-3102, People of the State of Michigan versus Mandel Berryman. Counsel.
I agree.
Look, now, Ken Bird on behalf of Mandel Berry, client waives the right to formal reading of five constitutional rights.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I'll hear your arguments as to bond.
Thanks, Judge. In this matter, the people are going to be asking for a $50,000 cash and surety bond. The defendant bond would be asking for a GPS tether, as well as home arrest and no contact whatsoever with the individuals involved in this. Your Honor, this case has to do with a 1-year-old who ended up getting shot in the face. The 1-year-old had to have reconstructive surgery, as well as surgery to the shoulder. The residence where the shooting ended up taking place was at defendant's house. Defendant knew that he shouldn't possess or have a handgun at his residence. Reason being, Your Honor, the defendant had previously been convicted 4 times over. Your Honor, there's, and I'm sure as Your Honor saw in the investigative report, there were multiple children inside of a house. They ended up getting a gun, which allegedly the defendant wanted in this matter had stated was in a lockbox. And we have forensic investigation interviews with the children who testified differently, who ended up finding it on a shoe. And Your Honor, I believe one of the individuals saw this on the shelf. Somehow it got in the hands of another one of the cousins, and ultimately, Judge, what we have here is a 1-year-old who ended up having to go through multiple surgical interventions.
Holy crap!
Your Honor, just for the allegations, let alone the fact the severity of the incident, this is assaultive in nature. Kind of unique. We've been hearing about these kinds of stories lately. Judge, unfortunately, this is just adding on to that list. The people feel justified in stating that the defendant is a danger, Judge, and as well as asking for the cash bond and GPS.
Okay, thank you.
Yeah.
I'm sorry.
Holy shit, you guys.
I'm sorry, Your Honor, and I just asked defense counsel if I could just say one more thing, just so it doesn't have to come back to me. As Your Honor will find, see in the report, it's basically on the second to last page, Judge. This defendant apparently has had multiple run-ins with CPS cases. These CPS cases, as it's stated, have been substantiated and is currently on the central register.
Oh,
okay. Thank you.
Lovely, lovely,
yes.
Lovely. Another shining example of why people should be locked away for life. So this case he's being charged with is the improper handling of a firearm. A 1-year-old got shot in the face. And there's a house with a lot of kids. He has CPS cases, and he is on the sex offender registry. Wonderful. No, he should be in prison. I'm sorry. This is someone I think that should get life. I mean, clearly he hasn't learned anything. Because, CSC, I believe they're all felonies. I don't think there's a CSC misdemeanor. I'd have to double check the statutes. It's been a while since I've looked at the laws, but holy crap. If this guy gets a plea deal, I'm going to absolutely lose my shit. I will. This guy needs his ass in prison.
5 children. living in his wife.
I don't care how many kids
This
he
is
has.
probation parole. He is employed for the family size of his, well below the 20% property guideline. Any amount of violence would not be remand to my client now. He does have medical problems. He was born with one kidney stone. Commercial farm next to the regular crucial. When it comes to this situation, the client indicates to us that he was working in the backyard. As we can see.
All right. Thank you so much for stopping by, Jerry. I will probably go here for a little bit longer. Enjoy the grandkids, okay? I'll see you next time, and thank you for stopping by. I seriously appreciate it.
Working in the backyard, 5 children in the house. He indicates to us that that's not his gun. It's not his gun, So even in the constructive way, I believe my client.
It's not his gun that makes it even worse.
But the council state that his co-defendant actually said that gun was in the safe. That gun was locked in the safe under the bed. The gun's in the co-defendant's name, So it's not my client. Not like my client had a gun on him. It's not like we have any witnesses that say they seen my client handle the weapon. They never. We don't have any witnesses that said they seen my client even put it on the shelf where it was allegedly found. Where one of the children said it was allegedly found. My client's not trying to run from this case. By this case, there's no way to say that my client is a threat to the community.
Yes, he is.
There's no way to say my client's a threat to the community. He's not going around trying to harm anybody. He was working on his home to take care of with his children and his wife.
Not trying to harm anybody, but he has multiple CSC convictions and has had lots of contact with CPS. Okay, he's not a danger to society at all. Let's ask his victims, because I'm pretty sure they say, yeah, he is.
Which he works hard to keep up. And respectfully, Your Honor, I do understand the severity of the situation, and it's unfortunate that we do see situations like this. But respectfully, ask this court for a personal bond in this matter.
And just for the record, the people never said that it was, the defendant claimed that it was his gun, but the defendant here on the screen knew that the gun was in the house.
And for the record, people said that he was in possession of the gun. That's almost like saying that my client, that the client was, he should have, no, people said he should have known.
One moment, please. Is this in the investigator's report that he had knowledge that the firearm was in the house and where it was in the house?
Yeah.
Okay, where is that, please?
Your Honor, I have on page, I don't know, Your Honor, where it speaks to the about halfway down the first paragraph. It talks about how
Okay, thank you. I'm looking at it now.
yeah, where it says the father made it known multiple times he had assumed the gun was locked in the lockbox underneath the bed.
So you've got him, he's telling me he has 4 prior felonies. I'm not seeing them. I was looking for what they were.
I have the previous, pulled out.
What are
Or
they, please?
previous felonies.
There are 2 different drug charges. We have RNO, and then we also have an additional drug charge.
Okay.
He wasn't charged with that.
No, I know.
But
That's why I'm asking.
Convictions. But Your Honor, just to answer your question on that page, he specifically stated to police he was aware that the firearm was in his weapon.
Okay. One moment, please.
Yeah, that's a problem. Because there's some very.
I mean, in some ways, I'm evaluating this like I would any other, like a DV charge, right? Not that he's a danger to the overall community, but how much danger is he to the people in his own home? But in a typical DV case, I have somebody who willingly engages in assaultive behavior against someone else, which I don't have here. This is careless if it's true. But I don't believe it's something that defendant wanted to have happen.
No, I don't think anybody wants it to happen, but it was apparently, I mean, there are very special set of circumstances that have to, like, things that have to be in place for someone to have a firearm when they're living with a felon.
It's a pretty extensive investigative report with multiple interviews with, it appears as though all parties, I think just, Your Honor, just to emphasize the point that their extensive investigation made it a point to put in the fact that there were other additional CPS cases that this defendant was previously involved in. So I can appreciate what Your Honor has to say about the defendant not wanting this to happen, but it appears as though this potentially could be some type of repetitive behavior.
All right, I'm going to ask you guys to just give me a few moments. I'm going to take a little bit of time with this investigator's report. It is lengthy. I'm going to just take some time with it. Just give me a moment.
Ooh. I wish I had that investigator's report to read. Let me tell you. That is crazy, you guys.
The children.
Okay.
You know, part of what troubles me here is the allegation that one of the children was interviewed and stated that they heard another child tell this child to get the gun. They then saw him stand up on a chair to get the gun that was on the black thing in the food area. He then got down from the chair and he had shot the other child. And so
oh my God,
it's difficult for me to believe that multiple children in the house know where this gun is and know that it's accessible. But defendant who lives in the home, another adult living in the home who can see that shelf doesn't. And so then that brings me to, is there a danger created by him being in the home with these kids? That coupled with prior CPS cases that are cited here, and it gives me no information that I can see really, and it is a lengthy report, so perhaps I've missed it. But it does tell me that there are substantiated CPS cases listing on the central registry, but no prior removals. So it does say there have not been prior removals. But this has now culminated in severe injuries to a child through what seems to be carelessness. There are no prior convictions used to enhance, although he is charged with felon in possession. I was looking for that because I don't even see what they are because they weren't used to enhance. But so now we've got somebody who I believe knows they're not supposed to be in possession of a gun or in a house with a gun. Looks like if the other kids knew there was a gun there, hard for me to believe he doesn't know there's a gun there, had not taken steps to secure it. I understand it's someone else's gun in the house and she's saying it was in a lockbox, but it's just difficult for me to believe just from this. And I'm not, he's not on trial right now. The only thing I'm trying to understand is if he goes home, what kind of danger does that pose? Is this kind of carelessness likely to happen again? Is something like this likely to happen again? And quite frankly,
yes.
If you know you're not supposed to be around a gun or have a gun in your possession and you have it in your house anyway, why should I believe that something like this might not happen again?
Yeah.
I don't.
Yep.
Just in the time it takes to get the case to the next step. Okay, it's going to pick up. It'll pick up whatever you're saying. So make sure you want it picked up. Okay. All right. Yes.
One thing out of the report, one thing the report does show, I do understand one thing the report does show that my client was never responsible for handling that weapon. By the time that he made it, in the initial confessions, first of all, everything that I see is the codependent that talks about how she handled how she used one statement that she assumed they hid it. She assumed that the children hid the gun from where she placed it, Your Honor. Also, where it says me statement she had seen the gun mark, which included on Aunt Lolene's hip, and that she knew the gun was on the shelf. Well, my client could have been working on it. We don't know the story yet, but my client could have been working out in the backyard. Probably could have came in and replaced, put that gun anywhere. It doesn't show where my client was ever responsible for handling that weapon and putting the kids in danger because of that weapon.
I mean, he knew it was there. Come on, he knew that gun was there. Don't tell me he didn't
All right,
know.
that being said, I will say there is one other statement in the investigator's report that does concern me. And that is the same child that was interviewed said that Mr. Berryman came into the house and stated someone needs to put that gun up while her aunt was still there. She stated that he then went back outside and the aunt left the house to cook, stated they were all told to go to the bedroom. So she assumed they hid the gun somewhere. And they later told him to get the cups off the shelf, and that's when he must have found the gun. So I don't know, there's a lot here that concerns me about how cooperative folks are going to be. That goes to flight risk. There's concern about the priors, knowingness of the gun there. I'm going to set bond in the amount of $50,000. I am going to set it as a cash surety bond.
Oh, thank God.
Additionally, though, during the course of this bond or until a judge says otherwise, there will be a GPS tether with full home confinement. And under that tether, while he's on home confinement until a judge says otherwise, he's not to reside with any minors.
Yes. We like that one. Good. Putting kids at risk like that.
That can, of course, be taken up at the next court date on Tuesday. Tuesday morning. That's going to be, what's my date? Tuesday morning. Where are we? We're at
20th. June 20th.
June 20th. All right. So this will be up for bond review hearing on June the 20th. June 20th in front of Judge McConico. You can, of course, address the amount of the bond and my bond conditions, which are the GPS tether with home confinement and no residing with minors. After that, court dates are going to be July 5th for probable cause conference, July 12th for preliminary examination. The prelim is set for 1:45 p.m. Both are set in front of Judge King. And Mr. Berryman, you are not to purchase or possess any firearms or other dangerous weapons during the course of this bond or to be in a home where they're found. That's part of this, part of the deal.
Ever.
All right. Thank you.
All right, guys.
But now what I do? I get a 50 cash or what?
Okay, guys, I gotta get going. My blood sugar is dropping, so I need to eat. Thank you for joining me. I know this is a much longer live stream today than normal. But like I said, I was just dealing with my lavender harvest and I was going to be watching this stuff anyways. So thank you for joining me, Chimagwitch. I greatly appreciate it. I appreciate all the support. Don't forget to hit that like and subscribe button. And if you could share this or just give me a shout out from time to time, that'd be great. If you really want to support my channel, in the description is the link for my memberships to my channel, and I do have a members only oh my gosh, what's it called? I told you my sugar's getting low. Discord. I have a members only Discord right now. I try to get on it. I think I haven't been on it like in a week, but like I said, I've been dealing with some health stuff. So It'd be great if you want to join my circle of friends. I'm hoping to get some content around. Next week is actually my 1-year anniversary from actually starting the channel, not from my very first video. They're my first 2 videos. So the real court watching stuff, next Thursday is actually my 1-year anniversary for that. And on Monday is my 10th wedding anniversary. So I might put something special together for that. I don't know. Anyways, again, thank you for joining me, and I will see you guys definitely next Thursday for my 1-year anniversary stream. All right, have a good one, guys. Bye.